Distinguished guests, honored speakers, colleagues, and friends, good afternoon. My name is Hili Cooperstein. I'm a third-year law student and a student at Rubinstein Center's Constitutional Leadership Program at Reichman University. And it is a profound honor for me to stand before you and moderate this conference. I would like to begin on a personal note. 2 years ago, at the beginning of the war, I had a conversation with my grandfather. He's a Holocaust survivor of Polish descent, a man whose life has been shaped by the deepest traumas of the 20th century. He said to me, "Hili, there's no future here. I would have told you to move abroad, but when I see the rise of anti-Semitism around the world, I understand that there may be no future for our people anywhere." This conversation shook me. It revealed something many of us are still struggling with today. The realization that historical trauma is not confined to the past. It continues to shape our political discourse, legal institutions, and our democratic confidence. It was around that time that I decided to study law. I chose law because I believe it is one of the few tools societies have to transform trauma into responsibility, memory into structure, and fear into principled action. Law cannot undo history, but it can determine how history informs the future. And when we look at the relationship between Israel and Germany, 60 years after the establishment of diplomatic relations, we see something extraordinary. A relationship that did not grow out of forgetting, but out of remembering. Not out of denial, but out of responsibility. A partnership that demonstrates that even the darkest histories do not have to lead to isolation. They can also lead to dialogue, commitment, and shared democratic values. This relationship reminds us of something deeply important. We are not alone. Not in confronting anti-Semitism, not in defending liberal democracy, and not in carrying the weight of history while still insisting on hope. It is in this spirit that we begin today's conference. To formally open the conference, it is my honor to invite Professor Amnon Lehavi, the Provost of Reichman University, to deliver the opening remarks. Professor Lehavi, please.
So, should we change the slide? Okay, good. So, good day, everyone. I'm Amnon Lehavi. I'm the Provost of Reichman University. I would like to welcome you to our symposium titled Never Again, The Burden of the Past and the Battle for Democracy, Israel and Germany at 60, co-organized by the Friedrich Naumann Stiftung für die Freiheit and our very own Rubinstein Center for Constitutional Challenges at Reichman University. Special thanks to Ms. Anne Cohen-Kohler from the Friedrich Naumann Stiftung, to Professor Leah Vorgad and Professor Yaniv Roznai, the academic directors of the Rubinstein Center, and of course to the incredible Tal Schulzinger-Beck from the Rubinstein Center for Constitutional Challenges, who is once again in charge of a meticulously organized event. Thank you very much to our distinguished speakers for today, those already in presence, Professor Aaron Barak, Professor Matthias Kuhn, and others, and those who will join us later today, such as the Honorable Ambassador of Germany to Israel, Stefan Seibert, who has been a prominent voice not only in the regular diplomatic channels, but also through a direct dialogue, in perfect Hebrew, I should say, with Israeli civil society, and I recall his numerous speeches in the Hostages Square and elsewhere since October 7. I assume that much of the conversation today will be about past lessons and how they affect our understanding of the present and future, especially in the context of the battle for democracy, given the domestic, regional, and even global political unrest and growing challenges for liberal democracies. But let me just say a few words about the passage of time and memory as we mark this year 60 years for the establishment of formal diplomatic, cultural, and academic ties between then West Germany and Israel, and of course 80 years to the end of the Second World War. As some of you may know, in 1998, an international conference was convened in Washington, D.C., following which a soft law instrument called the Washington Conference Principles on Nazi Confiscated Art came to life. It was the first of a series of soft law documents, including the 2009 Terezin Declaration and more recently the 2024 Best Practices for the Washington Conference Principles. And what these principles are about is trying to wiedergutmachen, to correct one of the most probably symbolic features of injustice to Jews, and that is the massive plunder of probably more than 500,000 works from Jewish owners between 1933 and 1945. And following the 1998 Washington Principles, 5 European countries, Austria, France, Germany, the Netherlands, and the United Kingdom, established restitution committees, which is a sort of a soft law ethical tribunal that discussed the return of Nazi looted assets to the heirs of the Jewish owners. And in an interesting development, Germany has recently abolished its advisory commission and moved to a system of binding arbitration. This means that all public collections in Germany, whether it's federal, state, or local, have basically committed to arbitration if the other party will be willing. And once you move to arbitration, and then basically you're moving from soft law to hard law in a way. And this slide here is about a lingering dispute, a very interesting dispute that is now taking place in the United States. And what you're seeing here on the left side is a painting by Austrian painter Egon Schiele of a Russian war prisoner done during the First World War. And this painting has been at the heart of a lingering dispute between the Art Institute of Chicago, that has purchased the item in 1966, and the heirs of the man on the right, Fritz Grünbaum. And it's really not only a story about a painting. It's a story about a person. It's a story about a family. And it's a story of a person who was a very prominent Austrian Jewish cabaret artist in Vienna. He was an outspoken critic of the Nazi regime and the racial laws against Jews. After the Anschluss on March 12, 1938, he tried to escape with his wife Elizabeth from Austria, but he was apprehended by the Nazis. He spent time in concentration camps, including Buchenwald and Dachau, until he was murdered in 1941. In July 1938, I should say, Grünbaum, when he was imprisoned in Dachau, he was forced by the Nazis to sign a power of attorney for his wife Elizabeth, and she was then compelled to permit a Nazi official named Franz Kieslinger to inventory Grünbaum's property, including his art collection, which contained 81 pieces by Egon Schiele. Sometimes after it was inventoried, Grünbaum's entire art collection was deposited with the Nazi-controlled shipping company and marked for export, though it appeared that the collection has never left Austria. Elizabeth was murdered in 1942, and in 1956, 65 pieces by Schiele resurfaced at an art gallery in Switzerland, managed by Mr. Kornfeld, and they were put on sale, and subsequently, many of them found themselves in galleries, in museums, not only in Europe, but also in the United States. And this piece was purchased in 1966 by the Art Institute in Chicago. Now, the interesting thing about the United States is that you can actually still submit civil court claims based on the 1916 Federal Act, which is the Holocaust let me recall here the name, it's the Holocaust Expropriated Art Recovery Act from 2016, which is now being extended for a period of 10 more years. And there are also criminal cases. And what I want to say here is that this case is still pending before an appeals court in the United States. And what's important here is not so much the artwork. It's the ability, 80 years after the end of the Second World War, almost 90 years after Fritz Grunbaum was murdered and taken from all his possessions, is that we get to tell and retell the story. And actually, sometimes the passage of times allows us to gain more information. And when you think about the fact that Yad Vashem recently announced that they have now reached the benchmark of having 5 million names of victims of the Holocaust, this means that, we tend to think that as time expires, memory fades. But if we act correctly, we can take advantage of our ability to gain more access to information, to tell and retell the stories of people, of family, of lives, of culture that existed and have been lost. And these past remembrances carry an important lesson for the present and the future. So we have to find ways to build up on commemorating the events of the past and thinking about the lessons that we can learn for the present and for the future. So thank you again all for convening here today, and I wish you a very successful conference.
Thank you very much, Professor Lehavi. It is now my pleasure to invite Mrs. Anna Cohen-Kuhler, Project Manager of the Israel Project at the Friedrich Naumann Foundation in Jerusalem, for opening remarks. Mrs. Cohen-Kuhler, please.
Shalom lekulam, distinguished guests. I'm truly honored to open this conference on behalf of the Friedrich Naumann Foundation, together with our partners at the Rubinstein Center for Constitutional Challenges on the occasion at 60 years of diplomatic relations between Germany and Israel. The title of this conference is Never Again, The Burden of the Past and the Battle for Democracy, Germany and Israel at 60. I guess it already signals that this is not a ceremonial anniversary, but a space for reflection. It is a special honor to welcome our guests from Germany, first and foremost, former Federal Minister of Justice, Marco Buschmann, as well as author Ahmad Mansour, and Professor Matthias Kuhm. Thank you for accepting our invitation and for coming all the way to take part in this conference. We are also deeply honored by the presence of former President of the Israeli Supreme Court, Professor Aaron Barak. As well as by the participation of many distinguished Israeli scholars whose work continues to shape legal, political, and democratic thought in Israel. At the Friedrich Naumann Foundation, one central reason for our work in Israel is the responsibility that grows from Germany's past. Through dialogue, exchange, and joint reflection, we seek to contribute to a deeper understanding between our societies and to the strengthening of our liberal democracies. But responsibility, I believe, is not only about remembrance. It is also about asking difficult questions, about how the past continues to shape our language, our instincts, and our political choices today. We often speak about never again as if it were a single lesson with a single meaning. In reality, it is a phrase shaped by trauma. And trauma can lead to very different, sometimes even contradictory conclusions about responsibility, security, and the use of force. This can create gaps in understanding between societies, between languages, and between lived experiences shaped by very different conditions. I would like to end with a personal moment that made this gap very tangible for me. And for that, I will now, if you allow me, switch to Hebrew, as it feels to me more natural in this context. ברשותכם, אני רוצה לסיים בסיפור אישי. ידיד יקר אליי הפציר בי במשך שבועות לכתוב מאמר על חווייתי כאם גרמניה שבנה גויס לצה"ל, ולפרסם אותו בגרמניה או באתר הפונה לקהל גרמני. היססתי. חלק מזה נבע מהאינסטינקט האמהי הבסיסי, הרצון להגן על הילד שלי וגם להגן עליו מפני שיח ציבורי שעלול להיות קשה ולעתים רעיל. וחלק מזה היה פשוט תחושת הצפה. הילד שלך מתגייס, הופך לחייל, ואת מנסה להכיל דאגה, רגשות ומחשבות מטרידות, הכל ביחד. אבל הייתה גם סיבה נוספת. הרגשתי שלא משנה מה אכתוב, רבים בגרמניה ובאירופה פשוט לא יצליחו באמת להבין את המציאות שאנחנו חיים כאן, לא מתוך כוונות רעות בהכרח, אלא משום שתנאי המציאות שונים לגמרי, ובהתאם גם האופן שבו המציאות הזו מובנת ומפורשת. לפעמים זה מרגיש כאילו אנחנו מאזינים לאותו סיפור, אבל על תדרים שונים לגמרי. ואז ברגע יומיומי לחלוטין, בזמן קיפול כביסה, נתקלתי בזה. סוואטשרט שהבן שלי הביא מהיחידה. על הגב הייתה תמונתו של חייל צעיר שנפל, עם מילים לזכרו. אני אתן את הקונטקסט, משפחות שכולות מגיעות לדבר עם חיילים ביחידה של בנם, מספרות עליו, על הדרך שלו, על החלומות שלו, ולעיתים מחלקות סוואטשרטים כאלה כדי שהזיכרון שלו ימשיך ללכת איתם. מה שתפס אותי היה שלא היו כאן סיסמאות של גבורה ולוחמה, אלא מילים פשוטות, צנועות, של זיכרון ואובדן. היה כתוב על הגב עם התמונה, ואולי ביום יפה ניפגש מתישהו, לנצח בליבנו. שלחתי תמונה והסבר קצר לחברה גרמניה. התגובה שלה הייתה מיידית, היא הביעה זעזוע עמוק. היא פשוט לא הצליחה להבין איך אפשר ללבוש דבר כזה, איך אפשר לשאת את זה על הגוף. מאוחר יותר שאלתי את ביתי, שלפעמים לובשת את הסוואטשרט בבית. איך זה מרגיש לה? היא הסתכלה עליי ואמרה, מה הבעיה אמא? המשפחה שלו רצתה שיזכרו אותו, עכשיו אני יודעת איך קוראים לו, עכשיו אני יודעת שהוא היה קיים. הרגע הקטן הזה נשאר איתי. הוא המחיש לי עד כמה טראומה מעצבת חברות בדרכים שונות. מה שנכווה כבלתי נסבל במקום אחד יכול להפוך לחלק מהיום יום במקום אחר. והוא גם הזכיר לי שעולם לא עוד אינו משפט אחד עם משמעות אחת. הוא נטוע בהיסטוריות שונות, בפחדים שונים, באינסטינקטים שונים של הישרדות. וזו בדיוק הסיבה שאנחנו כאן היום. לא כדי לחזור על סיסמאות ולא כדי להתחרות בטראומות, אלא כדי לנסות להבין איך השכבות הללו ממשיכות לפעול בתוכנו, וכיצד הן משפיעות על השיח הפוליטי שלנו, על המסגרות המשפטיות שלנו, ועל הדמוקרטיות שלנו, ולשאול יחד שוב ושוב מה משמעותו של לעולם לא עוד, אל מול האתגרים של זמננו. אני רוצה להודות לכם, ואני במיוחד רוצה להודות לשותפינו ממרכז רובינשטיין, ליאף וטל ויניב. תודה רבה לכם. שיהיה לכם יום.
We now move to the first session of the conference, Historical Traumas and Their Impact on Political and Legal Discourse. To open this session, I am pleased to invite Professor Liav Orgad from the Rubinstein Center for Constitutional Challenges at Reichman University.
Thank you, distinguished guests, colleagues, friends, students, and everyone who is here. Today's conference is not just important, but it's very emotional. It's decisive. Anna's personal anecdote and Ili's touching story are just a reminder that the topic that we discussed today is not another academic topic. And since it's emotional and also since language counts, with your permission, I want to speak in Hebrew. העם היהודי הוא עם טראומטי. הוא עם טראומטי לא כעניין קליני, אלא כתודעה היסטורית. לעולם לא עוד, ליהודים זה לא רק סיסמה, זה סיפור. סיפור מכונן שאנחנו מספרים לעצמנו שוב ושוב. תחשבו רגע על לוח השנה היהודי, לוח השנה העברי בישראל. בעצם זה סיפור של הישרדות. פסח, יציאה מעבדות לחירות, פורים, הצלה מגזירת השמדה, סוכות, יש לו קונוטציה גם של נדודים במדבר, בתוך סוג של פגיעות. חנוכה שאנחנו חוגגים לא רק נס ותקומה, אלא גם זיכרון על גזירות ורדיפות בגין זהות יהודית. וגם בימינו יש לנו את ימי הזיכרון, יום הזיכרון לחללי מערכות ישראל, ויום הזיכרון לשואה והגבורה. במילים אחרות, העבר אינו מת. הוא חוזר אלינו רק בגרסאות שונות. כמעט ונכחדנו, וכמעט והושמדנו, וכמעט וכמעט, ובכל זאת שרדנו, כנגד כל הסיכויים. הסיפור הזה עובר אלפי שנים, מדור לדור. הוא מפעיל את ההווה, אבל אני חושב שהוא גם מעצב במידה רבה את העתיד. בהגדה של פסח, ובכלל אני חושב דורות של יהודים אומרים משפט אחד, שהוא פשוט, אבל הוא גם מחריד. בכל דור ודור עומדים עלינו לכלותנו. זה בעצם משפט שמחנך ילדים לראות את העולם עבורנו, היהודים, כמקום מסוכן. ומי שלא גדל לתוך הלשון הזאת, מתקשה להבין עד כמה היא יומיומית, עד כמה היא חלק מה-DNA היהודי. אני רוצה לקרוא לכם כמה שורות שייתכן וישמעו מוכרות. וירדת משם ובאת אל תוך המרתפים האפלים. מקום נטמעו בנות עמך הכשרות בין הכלים. הבת לעיני אמה והאם לעיני ביתה. לפני שחיטה ובשעת שחיטה ולאחר שחיטה. שכבו בעלים, חתנים, אחים, הציצו מן החורים. ריבונו של עולם, עשה נס. הקטע הזה מתאר נשים יהודיות שנאנסות בפוגרום, כאשר בני זוגם עומדים חסרי אונים, מציצים מהמחבוא, צופים בעצם כיצד אונסים את נשותיהם, ומתפללים לאלוהים שיחולל נס. לא השביעי באוקטובר, זה נשמע מוכר, זה תיאור של פוגרום קישנב, בשנת 1903, לפני 122 שנה, ומי שכתב את הדברים הוא המשורר הלאומי חיים נחמן ביאליק, בעיר ההרגה. עכשיו, ביאליק עשה, אני חושב, דבר אכזרי, אבל הכרחי. הוא הכריח את היהודי הגלותי, להביט בעצמו, כמה אנחנו חלשים וחסרי אונים. הוא הפך את חוסר האונים לעוצמה, וגם לתודעה הלאומית. ומכאן נולד דחף עמוק, אז, לא לחכות עוד לנס. לעולם לא יהודים יהיו חסרי אונים. השאלה של הכנס, זה הכנס השני שאנחנו עושים בנושא, שנה הבאה יהיה כנס שלישי בניו יורק. השאלה של הכנס, שהיא שאלה שלא קל לענות עליה, היא מה עושה קהילה פוליטית שחיה בתודעה של לעולם לא עוד. כי תודעה של קורבן היא לפעמים כוח מוסרי, אבל היא יכולה גם להיות מלכודת. הרב דוד הרטמן כתב לפני כמה עשרות שנים מאמר נפלא קצר, אני ממליץ לכולם, שכותרתו אושוויץ או סיני. הוא הזהיר מפני מצב שבו השואה ותאי הגזים של אושוויץ הופכים לאירוע המכונן היחיד, ואני מדגיש היחיד, של הזהות הלאומית. של הזהות היהודית. והטענה שלו הייתה, הוא אמר, תראי, אם הזהות נבנית על נרדפות וקורבנות, כי אז הקורבן יתקשה לראות את עצמו בצד של התוקפן, בצד של מי שמפעיל כוח. וארטמן התריע שתיאור היהודים כקורבנות מוביל לתחושה של צדקנות עצמית. בעצם אף אחד לא יכול לשפוט אותנו כי אף אומה לא סבלה כמונו. והוא הציע לבסס את הנרטיב היהודי המכונן על סיפור יותר חיובי, על הפיכת ישראל לעם, מעמד הר סיני וההגדרה העצמית. לעולם לא עוד זה מנח דו-משמעי. יש לו מובן פרטיקולרי ומובן אוניברסלי. המובן הפרטיקולרי זה המובן שאנחנו מכירים היטב בישראל, לא עוד יהודי מושפל ומובל כצאן לטבח. המובן האוניברסלי הוא לא עוד דיקטטורות, לא עוד מלחמות עקובות מדם. והשנה, כשאנחנו מציינים 60 שנה ליחסים דיפלומטיים בין ישראל וגרמניה, יש שאלה עמוקה יותר, והיא איך חיים עם עבר שאינו עובר. איך חיים עם עבר שאינו עובר, בלי להפוך אותו לגורם שמכתיב בצורה משמעותית את העתיד. בעיקר, מה עושים כשהמובן הפרטיקולרי והאוניברסלי לא תמיד מתיישבים יחד ונדרשת הכרעה. אחרי מלחמת העולם השנייה נבנה סדר חוקתי ובינלאומי חדש, שעוצב במידה רבה בהשראת הנרטיב של לעולם לא עוד. המשפט האירופי, המשפט הבינלאומי, בגרמניה כדי להבטיח שלעולם לא עוד תהיה דיקטטורה טוטליטרית, ובישראל כדי לבנות בית לאומי לעם היהודי, שלא יהיה עוד חסר הגנה. מתוך ההבטחה הזאת נולדו גם מנגנונים חוקתיים שנשוחח עליהם היום בכנס, כמו דמוקרטיה מתגוננת, עקרונות יסוד שלא ניתן לשנות אותם ברוב רגעי בפרלמנט, וגם האפשרות לפסול מפלגות פוליטיות שחותרות תחת הסדר של פוסט מלחמת העולם השנייה של לעולם לא עוד והדמוקרטיה. והחוקות של גרמניה וישראל, אם תחשבו על זה, כמו גם של מדינות נוספות, הן חוקות שנכתבו מתוך פחד, מתוך מחויבות עמוקה לרעיון של לעולם לא עוד. והנה הפרדוקס, דווקא בשם לעולם לא עוד, יש שם מצדיקים כיום צעדים שמסכנים את הדמוקרטיה, מחלישים את האיזונים והבלמים, מגבילים את זכויות המיעוטים ומצמצמים ביקורת. וכשזה קורה, אז הדמוקרטיה מתחילה להיסדק. כי דמוקרטיה דורשת גם יכולת להגביל את הכוח, להגביל כוח דווקא כשמפחדים. ולכן המאבק על עתיד הדמוקרטיה הוא חלק בעצם מהמאבק על משמעות הטראומה. האם נלמד מהעבר רק פחד, או שנלמד גם אחריות? אני רוצה לומר לסיכום, תראו, אסור לנו להקל ראש בעבר הטראומטי של העם היהודי, האנטישמיות גואה, תחושת ההסתגרות, אני חושב שהם מצויים שיא רגשי, אבל גם שיא אובייקטיבי שמשתקף בנתונים. אבל בניגוד לפוגרום קישינב ולשואה, העם היהודי חזק היום. הוא יכול לבנות נרטיב תודעתי, אם לחזור רגע למאמר של הרב ארטמן, אושוויץ או סיני, שמבוסס גם על תקווה ולא רק פחד, על אור ולא רק על חושך. כי בסוף, לעולם לא עוד זה לא רק זיכרון, זה איזשהו פרויקט, הייתי אומר פרויקט של גבולות, שמדינות דמוקרטיות מציבות לעצמן תחת פחד. תודה רבה.
Thank you, Professor Gad. I'm honored to invite Professor Aaron Barak, former president of the Supreme Court of Israel and a professor at the Hari Radziner Law School, Reichman University. Professor Barak, please.
שלום. שלום, ערב טוב. שומעים אותי? When the state of Israel was established, a provision was put in. A provision was provided in our Declaration of Independence that we will have elections for a constituent assembly. The elections took place, the assembly was constituted, and the jurisdiction, their power was to write a constitution, but they failed to do it. And then decided to write chapters. Every chapter was named a basic law. This was not taken from the German Grundgesetz to the extent that I researched this wording. So they decided, instead of writing a full constitution, to write chapters. And the Supreme Court then decided that every one of those chapters is a regular statute. So no constitutional problem comes up. Only in 1992, when two basic laws were constituted, basic law human dignity and liberty, and basic law freedom of profession, those two basic laws which are our Charter of Rights, those two basic laws were later interpreted by the Supreme Court, and I wrote one of the judgments. We are just two members of the court that are still alive, saying that those two basic laws, and then I continued, and all other basic laws, are our Constitution. So you can see we are a constitutional infant. And as a constitutional infant, we wanted very much to look for help from other friends, from comparative law. And for me, comparative law means a friend. And so at first we moved to English law. And we learned a lot from the English common law as far as private law is concerned. But in England, as you know, they don't have a formal constitution, so the question of relationship between a constitutional norm and a sub-constitutional norm did not come up. So we moved it to American friends, because for me, comparative law is just a friend. So we moved to American law, and in the beginning, most of our young scholars went to America and received there their PhDs, etc. And suddenly, not suddenly, but sometime we found out that the American constitutional law may be a good law for America, which I doubt, but is a very good law, a very bad law for us, and that we should not write our judgments like the American Supreme Court does. And so we looked to other sources. And then we realized that there is the German Constitutional Code, the Bundesverfassungsgericht, and the Grundgesetz. And I'll tell you my own perspective. I was amazed by the methodology of the court and by the deepness of the literature in Germany. But of course, in the first years, to refer to German sources was impossible because of the Holocaust. I, as a Holocaust survivor, didn't have any problem with that. But the public had problems with that, and so we did not refer to it. But then a very important case was decided by the Israeli Supreme Court. And this case is called the Yardor case, and it was in 1965. And in the Yardor case, the question was, can a PLO party participate in the elections, though in its programs, they say that they are against the existence of the State of Israel? And look, when we looked around, there was no provision in any statutory or constitutional provision that deals with this question. So it was an open question. And it went to a court of 3 judges. One judge, the minority judge, decided that in the absence of any provision, let them participate. But the 2 other judges decided differently. The president of the Supreme Court, Justice Agranat, our biggest judge and most important judge, he interpreted the whole constitutional scheme, and he said, under my interpretation, they have no right to run for election. But there was Judge Zussman, who was one of our geniuses on the Supreme Court. And Zussman said, no. They can't run. And what were his sources? German law. So let me read to you the decision of Judge Zussman, in fact, which was never overruled. I myself think it's a wrong decision, but it was never overruled. And here is what Zussman said. The Federal Constitutional Court of Germany, which arose after World War II, was, as far as I know, the first court to declare that judges must apply unwritten constitutional principles that supersede not only ordinary laws, but even constitutional provisions that conflict with them. In its opinion, held on September 6, he refers to the case from 1953, German constitutional court cited with approval the following from a Bavarian constitutional court. You see how the judges Zussman knew German very well. He studied law in Germany. But all other judges of the Supreme Court, many of them knew very well the German language and the German literature. So here cites the Bavarian court, which says, the mere fact that a provision is part of the Constitution does not preclude its invalidity. There are constitutional rules of such fundamental nature and are an expression of supra-constitutional law, as to bind the legislature of the Constitution in his own right. And then Judge Zussman continues, if that is the case in a country with a written constitution, then all the more so in a country like ours, which lacks one. These fundamental super-constitutional rules, as relevant to our case, are nothing but the organized society's right to self-defense. Whether we call these principles natural law or whether we call them by any other name, I share the view that the lessons of history compel us not to repeat the same mistake we have all witnessed. The German Constitutional Court, in discussing the legality of political parties, see, you know this case, invoked that concept of militant democracy, one that does not open its gates to subversion discussed in legitimate parliamentary activity. As for Israel, I am personally content with the notion of a defensive democracy, which has the means to protect the state's existence, even if those means are not expressly detailed in the Knesset election law. You can see this decision of the Ardor case opened a door to the German constitutional law. Footnote, the door to German private law was opened even earlier. The BGB was known very well by our scholars here in Israel, and the idea of Trau und Glauben, Article 242 of the BGB, was repeated in one of our statutes, and now is the binding norm in the relationship between individuals. But as far as the relationship between the individual and the state is concerned, the Ardor case opened the door. Now there is already legislation which this government wants even to make more strict. But that's another problem. So I myself, in my writings and in my thinking, made many references to German constitutional law. And by my judgments, I think also the other judges of the Supreme Court and other courts are quite knowledgeable about the German rules. Apropos, I created a small group of experts to come here to Israel, and we were sitting together, and we went from one court to another court just to explain this, our constitutional scheme. Because as I told you, we were infants. And one of those, and one of them was a German, Nolte, Georg Nolte, who is now a judge on the ICJ, where I met him when I was an ad hoc judge. So let me just say very quickly, give you some examples. Interpretation. The theory of interpretation the court used was basically intent of the legislature, but we never looked at the intent. We took the English rules about it, but it was quite clear to me that intent cannot be the decisive concept. And then we moved slowly to the idea of purposive interpretation of any statute or constitutional provision. And we were, by doing that, I based my decisions on the theological ideas, which are quite common in the German theory of interpretation of statutes and constitutional provisions. Secondly, the question of the relationship between the human rights that we have a list of 7 human rights, and its relationship. Everyone agrees that those human rights affect the rights of a human being vis-à-vis the state authority. But does it affect the relationship between one human right and another human right? This was a question which was not decided in any basic law. There are constitutions which have a provision about it, like the South African constitution. So the question came before us, and I went very carefully into all the materials, and I found out that the most interesting, the most deep dealing with those questions can be found in the German literature about the Drittwirkung and the direct and indirect effect of it. And so the whole German theory of constitutional law dealing with Drittwirkung was accepted by us at the Supreme Court. Human dignity. The statute, our basic Bill of Rights statute says human dignity. Where does human dignity come from? From Germany. Article 1. And this is clear from the works of Parliament. This wording was put by a committee of Parliament, which was chaired by a retired judge of the Supreme Court, Benjamin Levy, who was from Germany, and knew Germany quite well. And he used the word Kvod Adam, human dignity, and this, by using it, he said, I mean by it what the German Grundgesetz is using human dignity, Menschenwürde. However, and I took it very, very, very seriously, and from this idea of human dignity, I gave the content of human dignity as I, in my judgments, wrote, means that every human being has the right to his autonomy, his right to write his own story of his life. Basically, relying on Article 2 of the Grundgesetz. But I said we cannot go fully with the German idea of human dignity, because the German idea of human dignity makes it a very, very strong constitutional right. It is absolute right, no limitation clause will apply, and it is an eternal right, no amendment can affect it. Our dignity is a regular statutory right, a constitutional right, It is a limited right, and it's not an eternal right. So I made all the necessary amendments that were needed to give to our dignity a much more scope than is given by now, until now, and now in the German constitutional law. Let me mention proportionality. Now, we have a provision about proportionality, and our provision was taken almost verbatim from the Canadian Charter of Human Rights. But the Canadian Charter of Human Rights, when it was construed by the Canadian Supreme Court, they decided that this, and in Canadian, the word proportionality doesn't appear. In our text, it appears. They said this means proportionality. Where have they taken it from? And I had to write a whole, and they didn't know about it in Canada. I had to write a whole article in one of the Canadian law reviews saying, look, Mr. Dixon, who was the president of the Canadian Supreme Court, he just copied it from the Germans, from the German literature. Though in Germany itself, the German Grundgesetz doesn't have a provision about proportionality, but it derives it from the idea of the rule of law, of the Rechtsstaat. And so there is a direct connection between us and the German idea of proportionality, which of course started in Prussia in the 19th century. And I wrote a book about it. And in my book, in Hebrew, and then I translated it into English, but I was not sure about my book. Does it make sense? So I asked Matthias Kuhn, my friend, read my book on proportionality and tell me, should I publish it? And he wrote about it, he had his remarks, he said, yeah, I can do it, go ahead. And I published the book. So here is my gratitude to Matthias Kuhn, that my friend Matthias Kuhn, that because of him I was able not to publish this book in English, and it was later published translated into other languages. It's quite common now, also in Spanish, etc. I'm finishing. I want just to make one remark. The German Constitutional Court is a very strong court. I think it's the strongest court in Europe, maybe in the world. Many democracies refer to the German Constitutional Court for advice and for comparative law. But let me tell to all the judges of the German Constitutional Court, and I know some of them. Dieter Grimm was here several times. If judges will not protect democracy, democracy will not protect the judges. I see it, the main role of judges all over the world, and mainly the German Constitutional Court, to protect our democracy. They should, in one of my judgments I wrote, when I sit on trial, I myself stand on trial. They should realize that all of them now stand on trial. It will depend on them very much how liberal democracies all over the world, which have problems, and in Israel, a dramatic problem, how all these courts will be able to survive and make democracy liberal stand and not disappear. The judges should not go into bunkers. They should stand and give their judgments and pay the price. And the judge, when they sit on trial, will be not hysteria, but historia. Thank you very much.
Thank you very much, Professor Barak, for your amazing and incredibly important words. I am pleased to invite Professor Matthias Kuhm from the New York University and Humboldt University of Berlin. Professor Kuhm, please.
It's a great pleasure and an honor to be here and to share the podium with my friend, colleague, and great judge, Aaron Barak. The topic today concerns trauma and its relationship to law and politics. In many ways, our legal world, the legal world that we live in today, is shaped by trauma. And it is shaped by trauma in two distinctive keys. There's a dark dystopian key, which to some extent seems to be particularly prominent in the present. I don't want to focus on that to begin with. We can have a conversation about that aspect maybe later on the panel. But what I want to do in the very limited time that I have is to focus on the bright side of how trauma has had a world-making, world-shaping, productive effect at particular moments in time. And more specifically, I want to focus on the moment of post-1945 after World War II. Because if we think about a post-traumatic situation and a post-traumatic moment, it must be that. World War II had ended, a genuine world war that in some ways World War I was not. So we call it World War I, but World War II was the first war which really had was a genuine global conflagration, in which roughly 75 million people got killed. And basically every country in the world was involved in some way or another. So it's a massive, aggressive war launched by Germany and secondarily Japan. And of course it led to the Holocaust with 6 million Jews murdered. And yet, here are three major shifts that occur just after or just around that time that give hope and suggests that trauma does not need to lead just into dark spirals. So here's the first. Already as the war was going on, the United States was building alliances to ultimately build a new kind of international legal order. By the time the hostilities had ceased in Asia, the UN Charter had already been signed. The Bretton Woods institutions, the World Bank, the IMF, had effectively been established and trade rules were in the process of being negotiated. I don't want to spend much time to highlight the deep structural shift that this new legal order constituted compared to the one that existed previously. But it was a transformative constitutional shift of the international legal order. So that's the first kind of major shift. It's a shift that kind of gave birth also to the idea in international law of human rights and of public authorities being restricted by the idea of respecting, protecting, and fulfilling human rights. Okay, that's one thing. Second point, the creation of a new state, of Israel as a Jewish and democratic state. That is the effect, one way of dealing with trauma, of garnering the energy, of working together, and to try to establish structurally, through creating institutions, new conditions which would ensure that this type of atrocity, tragedy would not occur again. It's a way to protect yourself against repetition. And the third that I want to spend a couple of minutes elaborating is another somewhat miraculous phenomenon when you really think about it, which was the creation of the German Basic Law in 1949. Because think about the situation of Germany at that time. These were not propitious times for exercising constituent power in Germany. When the Basic Law was enacted, only 4 years after World War II ended, Germans were suffering through, you might say, 3 different types of trauma. First, having lost World War II and facing the denazification procedures meant that many German citizens were forced to confront the question of their own responsibility and the role and the crimes perpetrated by the National Socialist regime in the name of the German people. This included the war of aggression, it included the Holocaust, and that's not a light burden to face if you were willing to face it at all. And not surprisingly, given the makeup of society and the variety of ways that people were implicated, not much of that actually happened at that point. The second trauma is, so this is the perpetrator's trauma, the perpetrator having to face himself. The second trauma had something to do with the fact that Germany too lost 7 million lives in the war, with further 12 million having had to flee or being subjected to ethnic cleansing from previous German territories, drawing of new borders, and the majority of survivors faced hunger and struggled to survive in bombed-out cities. These are the traumas of victims of a lost war. And third, and this is actually at the heart of the 1949 story, which typically in celebratory sessions is rarely emphasized in quite the same way, Germany was increasingly becoming ground zero in a new Cold War in 1949, with its remaining territory divided into East and West, and Germany as a people losing all agency. They were no longer agents. They were no longer able to shape their own fate. And even the moment of constitution giving, because that, if we think about collective action and self-empowerment and self-determination, that's the moment you'd expect to see it. But in Germany, that's not how it worked. The way it worked in Germany was that the Allies, and when I say the Allies, really what I'm talking about here is the Americans, who then built coalitions with the British first and the French, and then they spoke to the Netherlands and the Belgians and then after having talked to everybody and agreed on a position, they approached the Germans and said, here's what you're going to do. You're going to create a new constitution for the western part of Germany, the parts that are currently occupied by Western allies. And you're going to create a liberal democratic constitution and a federalist constitution. And you can do that, and we want you to do that. And you're within that framework free how you're going to do that. But beyond that, there's going to be an occupational statute which will ultimately count as the supreme law of the land. So that's the moment of exercising constituent power in 1949. And the reactions by the German representatives at that time was, we can't speak in the name of the German people. We are divided. We don't want to cement that type of situation by creating a new state, so no thank you. And then the Americans said, no, you want to do that, believe us. And then the Germans said, all right, but we're going to call it a basic law. It's not a constitution. This was kind of conceptual revolt against the imposition. But then, within those limitations, they set out to work. And within the limited framework, which actually turns out to be a productive one, they did what they could. And here's the interesting thing, and the thing that gives that makes the German constitution more than just a nicely drafted liberal democratic constitution, of which there are now many. And there were others alongside at that time. But what makes it unique is that they gave a very particular interpretation to the idea of never again. And the idea of, and the insight, if you like, or the claims that they made are the following. They did not face National Socialism. They did not face their past and its empirical richness, the specific atrocities that were there committed. They avoided all that. But what they did focus on was one thing, and it's a productive thing under the circumstances, given the difficulties to focus on. It was to say, how can we make sure, and what can we say to ensure that kind of a liberal constitutional democracy like Weimar was already, how it could not be hijacked and turned over into the kind of regime that then replaced it. We want to focus on deeply entrenching liberal constitutional democracy. That is our task, and that is what we set out to do. And in that, they succeeded in an original and creative way. And I'll stop by just highlighting 3 core features which made the German constitution distinctive in this regard. And symbolically, they started with human dignity. Aaron mentioned that. That's symbolically important. So rather than you are nothing, your people are everything, human dignity. That's a big counterpoint. But then comes the following claim. Human dignity is then in Article 1, Section 2. This is a section not as often emphasized in German public law because it has no immediate legal implication, but symbolically it's important. It says, because of the commitment to human dignity, human rights are the foundation of all justice and peace in the world. Every community in the world is bound by it. So there's a strong universalist commitment and understanding. This is basically Germany trying to inscribe itself into the civilized world again. But wanting that world to be one that is committed to such principles. And then the third, still Article 1, the claim that because of this, fundamental rights, human rights, constitutional rights, are binding on all public authorities and will be enforced by a constitutional court. They are binding law. They're not just political postulates. They are enforceable as rights before an independent and impartial judiciary in the form of the constitutional court. So that's a first core feature. The second one was to then go on and say, because this is, you make universalist claims, this is not a choice of we the people. This is not a constituent power that happens to believe this is a good way to go. Constituent power, we might say, it's not formulated like that in the Constitution, and as a legal claim it's even somewhat contested even today. But you might say, and I think it's a plausible interpretation of the Constitution, that they're saying constituent power is limited. It's not the power to create anything, positive law, out of nothing. The constituent power of the people is the power to work out a framework of self-government for those who conceive of themselves, those who are part of the political community, as free and equals. That's what constituent power is about. And anything else is simply not the grounds of plausible, legitimate authority. So what follows from that? It follows from that, first, that if there are constitutional amendments that are introduced that are incompatible with basic principles of liberal democracy, then they don't count. They're not valid. Invalid unconstitutional constitutional amendment. Secondly, it means that if there are political parties or political actors, individuals, who mobilize and campaign for public office and public power, who want to move away from an order constituted by such principles, then they can be prohibited. It is not a legitimate part of democratic politics to abolish democracy. So that's the idea of militant democracy in its most narrow and obvious form, prohibition of parties and specific candidates. And third, this was not introduced in the original Constitution 1949, but was introduced later when Germany remilitarized and created emergency provisions in its constitution. Along with those amendments, there was a new amendment which I always took to just be of declaratory significance because it just makes explicit something which is objectively true anyway, which says everyone has a right to resistance against those who seek to abolish an order based on these principles. You can abolish, you can change the constitution. You can invoke a new constituent power and try something completely different. But that completely different structure would still have to be one which is compatible with the basic principles of some version of constitutional democracy. Thank you.
Okay, wait, wait, okay. We'll now move to a dialogue entitled Defensive Democracy, a Renewed Perspective, with participants Professor Aaron Barak and Professor Matthias Kum. The discussion will be moderated by Professor Yoav Dotan, Hebrew University of Jerusalem, and fellow at the Rubinstein Center for Constitutional Challenges. Professor Dotan, please.
Good afternoon. Originally, I intended to ask you both two questions, one referring to the past and one referring to the future. But I think Matthias took an issue with my first question, which was, to what extent do you see the shared trauma, in a way, or the traumatic past of World II? To what extent do you think it affected the current constitutional arrangement both in Germany and in Israel? And as I said, I think Matthias, at least for Germany, took issue with this question already, but I'll give you a chance to expand on it, and for Justice Barak to refer to it in relation to the fundamental arrangement in Israel. And as already mentioned, there are shared, the fundamental constitutional arrangement in Israel and Germany are sharing some basic concepts, such as the concept of human dignity as the main pillar of the constitutional order. So this is one question referring to the past. But I have another question that refers to the future, or to our contemporary events that we all undergo, and that is, to what extent these fundamental arrangements in both systems are equipped to deal with perhaps the most conspicuous phenomenon of our time, that is democratic backsliding. We know that democratic backsliding is taking part in many areas, in many countries, many systems around the world, and both in the United States, in Europe. It includes Germany, but not only Germany. It includes the UK, it includes France and many other systems, and unfortunately for us, we envisage democratic backsliding also in Israel. So my question is to both of you, to what extent the current constitutional arrangements are equipped to deal with democratic backsliding, or maybe more generally, to what extent constitutional arrangements, any constitutional arrangements, can effectively guarantee human rights in the reality or against the background of democratic backsliding. How do you want?
Let me refer to your second question, as I think Matthias Kuhn touched the first one. I don't believe, you will be surprised from what I'm saying, I don't believe that courts can prevent a democratic country, a liberal democratic country, to become an illiberal democratic country or dictatorship. I don't believe courts can do it. Courts can prevent it going quickly, can prevent it going very smoothly, but the court cannot prevent the people from achieving what the people want. The court is a limited institution with limited resources, with limited knowledge, and don't expect the courts to prevent, the courts in any country, in Israel, the courts in Israel to prevent this sliding that you were talking about. Only one body can prevent it, and this body is the people. And it can happen in Israel by elections that we are supposed, hopefully will have at the end of next year. The court cannot act against the will of the people. Even if you will have a provision in the constitution that you cannot amend the constitution, etc., there's always this power of the people. There is, of course, another little question: can there be limits on the power of the people under those circumstances? That's another question.
I agree with that. Not surprisingly. But it's one thing to say, and I also assume that probably Aaron Barak will agree with that, it's one thing to say courts will not save committed people to go to hell in a handbasket if they're committed to doing so. But it's different, that is different from saying that there's no role courts could productively play to increase the chances of that not happening as quickly, or maybe not at all, because sometimes time is of the essence. So, for example, it's an interesting hypothetical. What would have occurred if the National Socialist Workers' Party, which was prohibited in 1923 after Hitler attempted a putsch against the Weimar Republic, if it had remained prohibited as it was as a result of the putsch. Because there was a law at the time which said that if a party did not stick to the rules of the game, then it could be prohibited on that grounds. But then Hitler came out of jail a year later and said, we now believe in the rules of the games. We'll comply with the formal procedural rules of the Weimar Republic, and we'll play the game and we'll try to capture the power by legal means. And then that was permitted. But now imagine, at that point in time, there had been a rule which said, A, such a party remains prohibited, as it would be under the German Basic Law today. And secondly, let's also assume there's a rule which says somebody who attempts a putsch like Hitler did would not be able to run for office anymore at all. So this is like in Brazil, for example, where Bolsonaro tried to do a Trump following his loss of elections and tried to instigate or try to create a situation where he would have a chance to maintain power. And as a result of that, within 3 months of that happening, there was an electoral court's decision, which as an administrative sanction, this is not a criminal procedure. It just said, okay, your behavior violates certain kind of basic norms of democratic appropriateness, and therefore you are now precluded from running for office for the next 10 years. And that's a death sentence for a politician. And so imagine the United States had done that to Trump, which they had arguably the legal basis of doing in Section 3 of the 14th Amendment, which the court interpreted, the Supreme Court, and then strangely said, and this was genuinely strange, that actually that particular provision requires implementation by Congress, knowing that would never happen under the real life circumstances, and therefore had no practical purpose. But there was a legal basis to basically preclude Trump from running for office. And I think that would not have solved everything. Trump is just a symptom. The problems go much deeper than that character or that movement that he stands for. But I do think persons matter. And I do think the possibilities of turning these difficulties into something more constructive may depend on the personnel that's available. And it may depend, on the one hand, negatively, on pulling certain persons out of the game. But of course, it also depends positively on there being attractive and ambitious politicians who stand for something better. So in the end, I do think that all these constitutional rules, they matter, but they are not ultimately going to save a political community, but they have a role to play.
Just to say that I agree, of course. And because I agree, you remember my remarks several minutes ago, that the court should not go into the bunker. Because going into the bunker means we will not play a role, which we may play. No, they should play a role as much as they can. And they can prevent many, many bad things. But when worse comes to worse, and the people are against the whole thing, then comes my remark that there are limits to what the court can achieve.
I would like to refer to this comparison between the US and Brazil. I think what made the difference between the US and Brazil, if you try to think, because the similarities between the US and Brazil are enormous in almost any respect. It's both, they have the same government structure, the same, more or less, the same share of power between the three branches. And also the fact that are related to the rise of populism in both systems are very much similar, simply because Bolsonaro just imitated Trump, or he tried to imitate Trump almost on any level. So if you ask yourself, what is the main reason for the difference, the huge difference in the chain of events, in what happened in Brazil and the United States, I would argue that this is a structure of the judicial system. That is, unlike in the United States, in Brazil, the STF, the Supremo Tribunale Federale, has concentrated power. That is, they are not only the Supreme Court, they are also the court that is in charge of enforcing criminal law against political corruption, and they have powers, as you mentioned, to oversee the electoral system. So it's not exactly the same tribunals, but it's more or less the same figures. So then, while in the United States, you don't have any of this. If you look at the criminal proceeding against Trump, they were completely diffused and dispersed between different courts, different prosecutors, and so forth. So I think it's not only people, but I think it's something that has to do with the structure of the judicial system. Now, if I go back to Israel in that respect, we are somewhat in the middle of the way. If you look at the structure of the judiciary, in the middle of the way between Brazil and the United States, in terms of the concentration of power within one court, because we do have one prominent institution, the High Court of Justice, Bagatz, which has many powers, but they don't have the same powers as the Brazilian Supreme Court has. For example, they don't have direct power, or I mean, what I'm saying is not completely accurate, because theoretically they can throw somebody out of the legal system, but it's not as easily, it cannot done as easily as it was done in Brazil and smoothly, and it is not entrenched in the Constitution. It's just a development of court law, of precedents. So I wonder, what's your take about that?
Well, I don't know too much about the Brazilian system. I was always amazed that the judges in Brazil are sitting and they have to discuss the case not in chambers, not among themselves, but before the public. And I was amazed. How can you do that? How can a court operate so openly? But probably there is a way to do it, which I don't know. I do think that the Israeli courts, the Israeli Supreme Court, has the powers which are needed to prevent it. A coup by the president, as it was in Brazil. And I think it's very important that our election committee is subject to judicial review. Whatever the election committee decides is subject to judicial review. And what is also provided, that a judge of the Supreme Court is the president of the election committee. It's very important. I hope they're not going to change it. So I think in terms of your question, our Supreme Court has almost or most of the powers which are needed to prevent a coup of Brazilian type.
I think it's very likely that the structure of the court system matters. But it's not decisive in these cases, I don't think. So I think if you ask, what is the core difference between, and I can only speak of Brazil and the United States, not so much for Israel, is that the timing. So these kinds of issues need to be dealt with swiftly. That means if you have a serious violation of the law, January 6 in the United States, 2021, the procedure needs to take place and be resolved in 2021. Because in 2021, everyone would have understood these procedures to address that particular act and the particular problem and address it irrespective of what the potential of that candidate is for future elections. By the time this actually came up to the Supreme Court, this is already 2024. He was already the Republican candidate and he was polling well. It seemed he might have a chance to win the elections, which of course in the end he did. And if the court had intervened at that point in time, it would have been seen as a clear intervention in a democratic process, pulling out a very promising candidate that might just win elections to favor another one. That's terrible. If that had happened, if the Supreme Court had decided differently at the point of time it was asked to decide, which is very late in the game, it would have been, the consequences could have been quite terrible. It would not have been a productive intervention. So I kind of have sympathy for the court doing with something that legally was deeply dubious and not very persuasive. But as a matter of statesmanship, kind of makes sense. But I don't think that's the whole story. I think the core issue is, and this goes to something that Aaron Barak said earlier, the intuition on the US Supreme Court is, and it's a misguided one, it's wrong, and Aaron Barak is right, which is to stay clear of anything that looks like a real political conflict. So we see this across the board, whether it's decisions relating to gerrymandering, whether it's campaign finance, whether it's anything that goes to the structure of the political process. There is an idea, John Hart Ely was famous for suggesting, that the core task of a constitutional court, it shouldn't meddle in too many things, but it should be the guardian of the fairness of the democratic process. That at least it should do. And the current US Supreme Court takes a position which basically says, if it's political, we regard it as a political question. This is a political question. If all we have is abstract standards of equality, with regard to gerrymandering, for example, then let the political parties do as they deem fit, and we will not review that. That's a political question. So there is the tendency to basically preserve themselves, I think this is what's driving it, by stepping back. And I think that's a very dangerous and ultimately counter-effective strategy. But if we want to see how that strategy plays out, then the United States currently is in Exhibit A to see how that plays out, because that is the strategy of the Supreme Court.
Just to add, in this respect of the timing you mentioned, Matthias, our court and our system allows those decisions that needed to be taken quickly. Because in Israel, you can go straight from the petition you have, from your complaint, straight to the Supreme Court. You don't have to go to other courts. You can go straight to the Supreme Court, and the Supreme Court can immediately give an order naisi, asking what's wrong here, and it can very quickly require the response of the state, and then can very quickly make a decision. In this respect, our system has this tool that you were talking about, and it's very, very important to use this tool. And therefore, I'm always hesitant when a case comes and the judges say, well, it's an interesting question. We don't have to decide it now. We will decide it sometime later. No, 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 no. In the times of today, you have to decide it now. You have to decide it quickly within the context that we have, and don't postpone it. And this can be done, and to the extent I know it, as I read the judgments, this is basically what they do. Not always I'm happy with the way it was drafted, but basically this is the result the courts have in Israel. So we have this very, very not natural situation where you go straight to the Supreme Court, so you save all the time. And the court having this power, don't give it up. Use it whenever those cases are coming, and think not only about case A, case B, case C, but think about what happens, case A, B, C, D, E. Think about the context in which we are. If you do that, you can help the people not to fall into a non-liberal democracy.
Yes, I fully agree with both of you that time is of the essence. But I think what Justice Barak just said, that the timing is affected by the structure of the judiciary. That is, whether you have concentrated or dispersed legal system. I think both in Brazil and in Israel, you have a concentrated system, and which is, I think, relatively unique in the sense that you can go directly to the highest institution of the land with no you don't need to pass any lower echelons. And this is something that is hardly can be done in the United States. It's not, I think theoretically the United States Supreme Court can take cases quickly if they want to, like they did, for example, after the elections of 2000. They dealt with it immediately, and they have this thing of the shadow docket and all that, but they don't normally do that, and they are not used to do it, like in Brazil and in Israel. And I think this says this is the main component that affects the timing of, or the timeline of the combat against democratic backsliding. Now, I think we have I think we can open the floor for questions from the audience now, the time that we have left. Anybody want to ask a question? Yes, please.
Thank you. The court, of course, is very important. But I asked, especially Professor Barak, how we defend the higher court. You see, today there is really a war against the court. So how can we defend it?
Well, I don't want to go too much into the Israeli specific political and other situation, but I do think the people can protect the court by many, many ways. They can, for example, demonstrate, go to the streets, say we believe the court, say we believe the president of the court. So there are means that within the militant democracy people can do, even, and in some cases it may seem that what they are doing is illegal, which is a problem, especially a problem for me to defend illegal activity, and that's not what I'm doing. What I'm saying is that we the people have tools in order to make the court do its job. But that's not enough.
I'm sure many of you are aware, particularly given the debates as they are also taking place in Israel, the idea that somehow the judiciary is an undemocratic intervention on what otherwise would be a democratic process, etc. And there are all kinds of answers that have been given to that type of challenge. But the best answer is one that insists that an electoral accountability process and the possibilities of citizens being able to challenge, to contest the outcome of a majoritarian process before an impartial and independent tribunal, that these two things go deeply together. They're both ways of empowering citizens, and they're both at the heart of a concept of constitutional democracy. So the idea is not that there is democracy and then, well, then we might have something else to police the democratic process. Courts and the possibility to contest majoritarian decisions should be understood to be at the heart of a comprehensive democratic process. Now, for that, the court has to be adequately structured, and there are certain additional conditions that need to be fulfilled. But nonetheless, it's important, first of all, intellectually, to insist that the two are joined at the hips. And secondly, of course, and that's the important point, is it makes a huge difference whether people in a democratic community actually believe that and then go out on the streets. And if there are challenges to the institutions, are willing to defend that, to go out, mobilize, and insist that there's something of importance for them that would be lost if such an institution was either abolished or massively disempowered.
So, and I absolutely agree, and I think that also Israel has demonstrated the strength of its democracy during the recent couple of years. You know, Leonard Hand once said that democracy does not exist on paper. Democracy is what exists in the hearts of the people. And I think that the Israeli public has demonstrated that you have a very big heart for democracy throughout the last 2 or 3 years with all the difficulties. Any more questions? Go ahead, please.
My question is, in Hungary, there was a very quick and big constitutional amendment in one foul swoop. How do you see a ordinary Hungarian citizen would react to a now constitutional court that is part of this total changeover? Do you see it as one big constitutional amendments, and what is the legitimacy of the Supreme Court of Hungary vis-a-vis Hungarian citizens?
Now, I'm not sure whether you're referring to, there was actually a new constitution enacted, so it wasn't just an amendment. This was the great criticism of Fidesz with regard to the previous constitution. They insisted that the problem of the legitimacy of the previous constitution, which was perfectly compatible with liberal democracy, but it was basically only a subtly amendment version of the constitution that existed under the socialist regime. And so if you wanted to have a genuine free constitution, you needed a new one. And then it just so turns out that surprisingly nobody expected that. They had the majority to actually enact a new constitution, which they did. And then you have and now we're in a very different constitutional world. And now the question is, how would one imagine getting out of that? Again, how do citizens react? Well, I mean, at the moment, the governing coalition still enjoys strong support. It will be very difficult to change, to move beyond this in a deep structural constitutional way. So this raises all kinds of issues as to how you undo these types of acts which were a move from a liberal democracy to an illiberal democracy, to some kind of more authoritarian structure. And there are hard and difficult questions there, and we could have a whole seminar talking about them, but unfortunately there's no quick silver bullet-like answer that I can give to that question.
Please.
I want to continue my question. Professor, distinguished professor spoke about demonstration. Well, demonstration, but it's not enough. I would like to know if there is something in the law or part of the Constitution to fight during the judicial way against to limit the power of the majority. What is done today?
Well, I think what Israel demonstrated, the strength of public protest, because on paper our constitutional guarantees are pretty weak. We don't have an entrenched constitution. We have some basic laws, but formally they are up to change by the Knesset by regular majority. So these are, from formal point of view, these are very weak constitutional guarantees. And yet, if you look at what happened in Israel in the last 3 years, although the government had a solid majority in the Knesset, and although they had the formal power to change the constitution, if you measure the actual success in transforming the Israeli constitutional system, their success was very limited. Largely speaking, so far, and knock wood, the so-called reform introduced by the government 3 years ago did not pass. They have passed here and there some relatively small changes. Maybe they succeeded in 2 or 3% of what they planned. And that was done with no constitutional, no formal, or with very weak formal constitutional guarantees, I think.
We have only a couple of minutes left, and I have, if it's not inappropriate, I have a question for you, Aaron. You were ad hoc judge on the ICJ when South Africa filed its petition against Israel for genocide. What was your experience of the institution of the process at the court? How do you come away from that process? Did it strengthen, did it undermine your faith in international institutions? What were your impressions in that regard?
I spent almost a year, less, in the ICJ. In Israel, there is a mixture between the ICJ and the ICC. Whenever now there was a decision by the International Criminal Court, the pictures they shown on TV is the ICJ. So I'm not talking about the ICC. As far as the ICC is concerned, I think that the arrest order that the court issued on the request of the prosecutor was wrong, and I have done my best. I try to, because I have some connections with people around the prosecutor, I tried to convince them to abolish it, not because of my like or dislike to the people who were ordered, against whom this order was given, but because in my view, an order against the Prime Minister of Israel is an order against Israel. And this, I think, was wrongly done. So that put aside the ICC. Your question, rightly so, has to do with the ICJ. I was accepted by them open-handed. They knew my work. They read my books. And they knew, which I told them from the beginning, I'm not an agent of Israel, as you are not agents of the countries from where you come. We are agents of justice. And so let's see what does justice say in terms of international public law. And my feeling is that this is the way they think about it. For example, what I was faced was the request of South Africa to issue an order for Israel to stop fighting in Gaza. And I told the judges, you are asked to give an order to stop fighting in Gaza. Are you going to give also a judgment that the Hamas would stop fighting in Gaza? The answer is no. The court has no jurisdiction as far as Hamas is concerned. So it will be just an order against Israel. And then I cited to them one of my judgments in which I said that when a democracy fights terror, it fights with one hand behind its back. And it will prevail because the one hand it fights with is the hand of the rule of law. Now what you are asked to do is that Israel will fight with the two hands behind its back. And I think the judge understood it, accepted it, and I must say, even the president of the court then was a person who is now the Prime Minister of Lebanon. I knew him very well. And I gave him my books as a gift. and I hope I'll be able sometime to visit him in Lebanon, in peacetime, of course. So my belief in international law, justice, was strengthened, not weakened. I have seen the seriousness in which my views were taken. There, everything goes according to seniority, everything. So the junior starts, and the president, who is the senior, finishes. And so they accepted my view, and they understood the problem of Israel, and no order was given for Israel to stop fighting in Gaza. The order that was given was stop fighting in Gaza in a way that you commit genocide. And I think Israel was fighting in Gaza probably by violating some rules of humanitarian international law, but not genocide. And even the chief prosecutor, when he asked the orders against the Prime Minister and the Minister of Defense, did not cite genocide as the reason for that, because he knows that genocide is the most serious criminal offense, that you need a very high, very, very high requirement of mens rea, namely of intent to commit genocide, and this very, very high intent was not there. The case is not over yet. It will take some years until it will be over, and probably one of my remarks is that they should do it quicker. But they have a lot of work. Don't think that they sit with, they have a lot of international problems, more important, less important. They have also not only the case that I was involved in, but they have also advisory opinions they have to give to the UN bodies, etc. It should go quicker, and I think that this shadow of genocide, and you can imagine, Matthias, how difficult it was, and I told it to them, how difficult it is for me, a Holocaust survivor, to sit on a case in which Israel, my country, not my principal, not the one who sent me, but my country commits genocide. And they understood it very well. So my belief in international law was not weakened by my experience. On the contrary, it was strengthened by my experience.
So our time is up, so thank you very much.
Thank you to all participants. We now move to a dialogue entitled, How Do Democracies Confront Internal Anti-Liberal Forces? It is my honor to invite author Mr. Ahmed Mansour and Mr. Ben-Dror Yemeni, journalists at Ediot Achronot. The discussion will be moderated by Mrs. Amit Tomer, journalist at Channel 12 News.
זהו, נכנסו, יצאו. אז היי, אנחנו עומדים לדבר היום, כמו שכתוב מאחוריי, על איום שהוא כבר יותר מתופעת שוליים, וזה בעצם קבוצות וזרמים אנטי-ליברליים מבית שהולכים ומתרחבים מסיבות דמוגרפיות ולא רק, עד שבמקומות מסוימים הם אפילו עלולים להפוך לרוב, כבר הופכים במדינות מסוימות. ויש לנו כאן שניים שככה ייתנו לנו כמה שיעורים באיך צריך או אפשר להתמודד איתם. אני רוצה להתחיל איתך, אחמד, וקודם כל להגיד לך ברכות, כי שמעתי שזכית ממש עכשיו בפרס הנס מרטין שילר על עשייה ציבורית נגד אנטישמיות ורדיקליות בגרמניה. אז אני אשמח לשמוע על הפעילות שלך שם, אבל אני אתחיל אולי דווקא משאלה יותר רחבה, כי אנחנו מדברים בשבוע שבו התרחש פיגוע נוראי באוסטרליה, שגבה חיים רבים, ואתמול במקרה בגלי צה"ל ראיינתי את מנכ"ל משרד התפוצות, והוא אמר, באלו המילים, זאת לא פרשנות שלי, העברנו מידע לאוסטרליה, היו התראות לפני כן, הם לא רצו לעשות עם זה שום דבר, הם לא רצו להקשיב. ממשלת אוסטרליה, אלו לפחות האשמות בישראל, כלומר זה לא רק עניין של איזה קומץ שוליים, אלא יש פה משהו שהוא ממש מאורגן, שלפחות העלמת עין. עד כמה הדבר הזה בעיניך הוא רחב, או שברוב המקומות אנחנו עדיין רואים את זה כאיזשהו קומץ שמנסים בכלל להילחם בו ביומים האלה?
קודם כל, המון תודה על ההזמנה. זה לדעתי הפעם הראשונה שאני מדבר בכנס בעברית, אחרי 21 שנות גלות בגרמניה. אני מקווה שהעברית שלי תעזור לי להעביר את המסר. אני חושב שאני עוקב בעיקר אחרי השביעי לאוקטובר המון על התקשורת הישראלית, ויש איזו מילה אחת שמשתמשים בה לשיח הציבורי בו, שאפשר להשתמש בה גם בקשר הזה למערב, והיא נקראת מכונת הרעל. ומכונת הרעל שמתרחשת מאז השביעי לאוקטובר, כל האנטישמיות שהייתה תמיד שם, אבל היא התפרצה, היא נמצאת ברחובות, היא נמצאת בשיח התקשורתי, אבל היא גם נמצאת ברשתות החברתיות, ומה שהתרחש כרגע באוסטרליה, מה שהתרחש לפני כמה חודשים באנגליה, מה שמתרחש כמעט יום-יום בהמון מקומות, הם תוצאה של מכונת הרעל הזאת של אנשים אנטישמיים. זה לא קשור לסכסוך שמתרחש כאן. זה לא קשור אם ממשלת ישראל עושה הכל בסדר או לא. זה לא קשור לרוצים שתי מדינות כן ולא. מי שיוצא לרחובות בברלין וקורא From the river to the sea, הוא לא מעוניין בשני מדינות. הוא בן אדם שיש לו בעיה עם עצם קיומה של המדינה הזאת. ויש שיתוף פעולה אסטרטגי שנמצא כבר 10 שנים בהכנה, ומאז השביעי לאוקטובר, ובן דרור יכול להרחיב על זה, של שמאל פרוגרסיבי, זה כל פוליטיקת הזהויות ביחד עם הפוסט-קולוניאליזם, שבעיקר באקדמיה מאוד מאוד חזק, ביחד עם קבוצות אסלאמיסטיות, שנטל למכונת הרעל הזאת להיות מאוד מקצוענית ולהשיג המון אנשים. וזה לא רק להוביל אנשים לרחובות, כאילו להיות נגד ישראל, אלא זה גורם לקבוצה מאוד קטנה של אנשים גם להקצין בצורה כזאת שהם מוכנים אפילו לעשות פיגועים. ואם את תסתכלי על הפיגועים שהיה לנו בגרמניה בשנה הזאת, ואת תבדקי את הביוגרפיות שלהם, ובעיקר תבדקי למה הם בעצם הקצינו דתית. חלקם היו לפני שנה ושנה וחצי בכלל לא בכיוון, והם יגידו לך בעצמם שהמלחמה בעזה והתמונות שהם ראו בטיק טוק והשיח הציבורי והשנאה שקיימת במרחב שהם נמצאים פה גרמה להם להקצין כל כך רחוק עד שהם היו מוכנים לבצע פיגועים.
אז למעשה אתה אומר האיומים שאנחנו מתמודדים איתם, יש כמה זירות, יש את הזירה הפיזית שאולי באמת ככה איום מבית, אבל יש גם איומים ברשתות החברתיות שלפעמים יכולים להיות גם ממקומות אפילו אחרים ולהשפיע ולייצר איזה אפקט פרפר שמרחיב את התופעה הזאת ליותר ויותר מקומות. ובן דרור, אתה בדיוק חזרת מסיבוב של הרצאות בקהילות יהודיות, אז ככה דווקא ראית את השטח מקרוב, את הפנים שמאחורי המסך. עד כמה זה בהתרשמות שלך איום שמשפיע על היום-יום שם, ועד כמה אנחנו נוקטים צעדים כדי להתמודד איתו?
שני דברים. א', כן, הייתי בקהילות יהודיות, הייתי בקמפוסים, חזרתי רק לפני יומיים. מה אנחנו עושים? קרוב לאפס. פשוט קרוב לאפס. כי כאשר אני נמצא שם בקהילות יהודיות, והם שואלים אותי שאלות, והם שואלים אותי איך אנחנו מתמודדים עם טענות שמופיעות בעמודים הראשונים, בלמונד, בניו יורק טיימס, ובעוד עיתונים מובילים בעולם, איך אנחנו מתמודדים? אז יש לי חדשות בשבילכם, ישראל לא נמצאת שם. ישראל פשוט לא נמצאת שם, היא לא קיימת. אז אני יודע לספק חומרים, כי זה התחום שלי, אבל אנחנו בבעיה. בחברה הליברלית, בחברה שמקדשת את הדמוקרטיה, את חופש הביטוי, לימדו אותי בשיעור הראשון במשפט חוקתי, שיש 3 הצדקות לחופש הביטוי, אחת מהן זה שב-market place of ideas, eventually truth will prevail. האמת תנצח בשוק הדעות, זה מה שלימדו אותי. יש לי חדשות בשבילכם, נדמה לי שצריך לשנות קצת את הקוריקולום של השיעורים האלה. האמת לא מנצחת. האמת לא מנצחת. בחברות הדמוקרטיות הליברליות, האמת לא מנצחת. כאשר הניו יורק טיימס, אנחנו שואלים את עצמנו למה? למה זה קורה? יש תוצאות. הנה את התוצאות ראינו במנצ'סטר, את התוצאות ראינו בוושינגטון ברצח שהיה לא מזמן לפני 3 ימים. אלה התוצאות. אלה התוצאות, ומי שלא מבין את הקשר בין השקרים שמופיעים בעמודים הראשונים לבין העובדה שיהודים נרצחים, פשוט נדמה לי שיש לו בעיה בהבנת החומר. עכשיו, יש לי הרבה מחלוקות, אני חייב להודות, עם פרופסור אהרון ברק שיושב כאן, אבל אני זוכר שהוא פרסם לפני הרבה מאוד שנים הצעה להכיל את כללי המשפט הציבורי על העיתונות. והיה ויכוח גדול, נדמה לי, אולי הפרופסור יתקן אותי אם אני טועה, נדמה לי שהייתי היחידי שיצא להגנתו. היחידי שיצא בתקשורת להגנתו ואמר, אתם פשוט לא מבינים, אבל הוא צודק לחלוטין בעניין הזה, ואני שמח דווקא לדבר על דברים שאנחנו מסכימים עליהם, ולא על הדברים שאנחנו לא מסכימים, אבל הוא צדק לחלוטין. הוא פשוט צדק לחלוטין, כי אנחנו רואים את התוצאות. רק כדוגמה, כדי להבין באיזה עולם אנחנו נמצאים, באיזה עולם מתמודדים רבים וטובים ופחות טובים. עיתונים רבים בעולם פרסמו תמונות של ילדים גוועים. הנה הוכחה שישראל מבצעת הרעבה. 12 ילדים היו כוכבי הקמפיין הזה של ההרעבה. עכשיו, אני לא רוצה כרגע להיכנס לסוגיה, כי זה לא הנושא שלנו, מה בדיוק קרה שם בעזה. כל 12 הילדים סבלו ממחלות אחרות שאין להן שום קשר. תחקיר מצוין של פרי פרס, של ברי וייס, מי שיודע על מה אני מדבר. עכשיו, חלק מהעיתונים הודו, הניו יורק טיימס למשל, שפרסם תמונה זוועתית בעמוד הראשון, פרסם. זו הייתה טעות, זה בכלל לא זה סובל בגלל מחלה. עכשיו, כמה אנשים נחשפו לעמוד הראשון, שהם לא קוראים אותו בכלל כי הוא מופיע על הדוכנים, כמה אנשים נחשפו לרטרקשן, סליחה, טעינו. אולי 0.5%. אולי 0.5%. עכשיו, כשאתה קורא את הדברים האלה, אבל אתה קורא אותם כל הזמן, אבל כל הזמן, שוב ושוב ושוב, אם לא הייתי יודע, אם לא הייתי עוסק בחקר הנתונים, יש לי חדשות בשבילכם, הייתי הופך לשונא תהומי של מדינת ישראל. שונא תהומי של המדינה הזאת. כי מה אתם עושים? ג'נוסייד, לא נכון. סטרוויישן, לא נכון, אבל זה מה שהם מאמינים, ואני בא משם, והרבה מאוד אנשים טובים ויקרים, יהודים ולא יהודים, מאמינים באמונה שלמה שישראל היא המפלצת עלי אדמות. המפלצת עלי אדמות. עכשיו, סימן שאלה גדול. ואני חייב לקצר, סימן איך מתמודדים עם הדברים האלה? אנחנו בעידן אחר. שלא לדבר על הרשתות החברתיות, רק כדוגמה, בטיק טוק היחס בין דברים שמגינים על ישראל לדברים שלא מגינים על ישראל הוא 17-1. איך אתה מתמודד? איך אתה מתמודד עם הדברים האלה? עכשיו, אני שואל פה שאלות, כי התשובות שאולי נתחיל לתת, יחרגו מהכללים שאותם יישמנו ובתי המשפט המכובדים בישראל ובעולם, הכללים שהם קבעו, גם לגבי חופש הביטוי, גם לגבי דברים אחרים. אז יכול להיות, רק יכול להיות, שאנחנו חייבים עם עצמנו, כולנו, אנשי המשפט שיושבים פה, איזושהי חשיבה מחודשת. הכללים הישנים לא עובדים. חובה על כולנו לבצע איזושהי חשיבה מחדש, כדי שהדברים האלה לא יקרו, כדי שנצליח להתמודד איתם. כרגע אנחנו בכישלון היום ונורא, לא מתמודדים.
יש כשל איזושהי סתירה פנימית במה שאתה אומר, כי התחלת מלהגיד בעצם כל הליברלים צריכים להבין שאולי הם צריכים להיות קצת יותר כמו מכונת הרעל, כי זה מה שעובד. ומצד שני דווקא הדוגמאות שתיארת עכשיו הם לכאורה מגיעים מציבורים ליברליים. הרי גם מהניו יורק טיימס וגם האנשים שקוראים את הניו יורק טיימס וידדו את המסרים האלה ולא ידדו באותה עוצמה את התמונה, את העברה על אותה התמונה, הם אנשים שלפחות קוראים לעצמם ליברליים, ואני חושבת שהם מחזיקים בערכים ליברליים, הם פשוט לא נותנים לעובדות לבלבל אותם. אז יכול להיות שאנחנו כבר בעצם רואים את ההשלכות של אותה מכונת רעל פופוליסטית מתרחבת לכל הזרמים, אולי הם עושים את הדבר הנכון. מה זה משנה העובדות? העיקר הנרטיב.
אני לא רואה את הסתירה, אבל בוא נגיד שיש סתירה. סקוט פיטג'רלד אמר שרק אנשים שיש להם חשיבה קצת יותר מורכבת יכולים להחזיק בשתי עמדות סותרות באותו זמן. אז יכול להיות, לא. עכשיו, כאשר אני אומר ליברלים, אני לא רוצה לעשות הכללה. כמובן שיש ליברלים שהם חלק מהמפלגה שלי שלא קיימת, יש ליברלים שהם חלק מהמפלגה שלי שלא קיימת, ויש ליברלים היום, כאשר אומרים ליברלים, אנחנו מדברים על קשת מאוד מאוד רחבה. קשת שמתחילה בעצם באנשים שבאמת רוצים חברה טובה יותר, נאורה יותר, מתקדמת יותר, ואנשים שעברו למקומות הזויים לחלוטין, הפרוגרסיביים, הווק, שבעצם אין שום משמעות יותר לאמת, אין שום יותר משמעות, זאת אומרת כאילו אצלם יש חזקים וחלשים, ומכיוון שהפלסטינים מצטיירים, לא יודע אם זה נכון, אבל לצורך העניין כחלשים, אז באופן אוטומטי ישראל היא המפלצת והם הקורבנות וכו'. אבל כאשר אני אומר ליברלים, זאת אומרת יש פה איזשהו טווח מאוד מאוד גדול. יש ליברל, אני חייב, כי זה חלק מהשיח שלנו, יש ליברל דגול לדעתי, דיוויד גוטהרד, שפרסם לפני 2004, 21 שנים, מאמר שגרם לי, וזה בדיוק התחום שמנסור עוסק בו. ואני חייב לומר שבשבילי זה היה מאמר שגרם לי לחשיבה. הרי כולנו בדרך כלל כשקוראים דברים אנחנו אוהבים לקרוא את מה שאנחנו אוהבים ולא את משהו שמאתגר אותנו. ככה אנחנו, זה הטבע האנושי. אבל הכותרת של המאמר הייתה Discomfort from strangers, אי נוחיות מזרים. עכשיו מכיוון שהוא ליברל, עורך הפרוספקט בבריטניה, עיתון מכובד, והמאמר פורסם בגלל החשיבות שלו ובגלל הרעש שהוא יצר, פורסם אפילו בגרדיאן, היום הגרדיאן אולי לא היה מפרסם, אבל בשנת 2004 הגרדיאן פרסם, ובתמצית מה שהמאמר הזה אומר, תראו, זה בסדר שאנחנו מקבלים הגירה, זה היה הרבה לפני הגלים האחרונים, זה בסדר שם, אבל שיהיה רק ברור שככל שנקבל יותר מהגרים החברה תהיה פחות סולידרית. יהיו לנו הרבה פחות בעיות, כי מה לעשות, אבל הם לא מצטרפים לאתוס המשותף, אם בכלל אנחנו רוצים את האתוס המשותף. והוא אמר, יש בעיה, ואנחנו כליברלים, הוא דיבר אפרופו, השאלה שלך, חייבים לחשוב על העניין כליברלים. וכליברלים אנחנו בבעיה, כי יש פה את הפרדוקס הגדול. ככל שהחברה תהיה מגוונת יותר, היא תהיה פחות סולידרית. אז זאת אומרת, מה, אנחנו רוצים חברה הומוגנית? סימן שאלה. אבל ההטרוגניות תביא איתה הרבה מאוד צרות, אותן צרות שמחמוד יודע לדבר עליהן הרבה יותר טוב ממני.
אז אני שמחה שככה הזכרת את זה, כי אתה לוקח אותנו לסיפור הקצת יותר רחב, כי באמת האנטישמיות זה רק אחד התחלואים של אותן קבוצות אנטי-ליברליות. אנחנו רואים באמת פעילויות נגד להט"ב, נגד מיעוטים אחרים, נגד נשים לפעמים, זכויות נשים, וכל אלו בעצם חונים תחת באמת מקשה אחת של ערכים יותר מה שנקרא לאומניים, ובעצם מצד שני הליברליות הייתה אמורה לתת תשובה לכל אלו, ופחות לקדש את איפה אנחנו נולדנו ומה אנחנו, מאיפה אנחנו באנו, אלא את סט הערכים שלנו, ולכן מן הסתם הליברליות הובילה להרבה יותר הגירה. ודווקא עכשיו כשמנסים לצמצם את זה, ואני חושבת ששניכם תומכים בדבר הזה, אני רוצה לשאול אותך, איך אפשר אז כן לייצר חברה שאינה מבוססת לאום, לאפשר להגר במדינות, לאפשר את העולם החופשי, אבל אולי להגביל את זה באיזשהו סט ערכים. יש דרך לעשות את זה?
קודם כל, אולי הערה מאוד מאוד חשובה. אנחנו מדברים עכשיו על כל מה שקשור לאנטישמיות ועל הפיגועים שקרו, אבל אני חושב שאנחנו צריכים להסתכל על זה מזווית אחרת. העולם כולו עובר כרגע שינוי אדיר. אנחנו דיברנו על העיתונות. העיתונות הולכת ונעלמת. גם מה שקורה עכשיו בקשר לישראל וגם בקשר לאנטישמיות, אבל בנושאים אחרים לגמרי יש בעיית אימון אדירה, ובעיית האימון הזאת היא שגם נגד הממשל ונגד הרבה מאוד דברים שקשורים וחשובים לדמוקרטיה, נובעת מזה שאנחנו חיים בעולם שהסובלנות לעמימות כמעט ולא קיימת. האנשים רוצים תשובות מאוד מאוד ברורות. אנחנו מתחילים בגרמניה אפילו לראות שהאנשים שמתחילים להרוויח פוליטית זה אנשים שמבצעים שיח פוליטי אחר לגמרי מאשר אני הכרתי אותו ב-20 שנות האחרונות. תשובות מאוד מאוד פשוטות, הצורך במנהיג מאוד מאוד חזק, הפולחן האישי שנמצא גם פה, זה משהו שקיים בכל העולם והוא מגיע מהעובדה שאנחנו נמצאים בעולם פוסט אמת, שהאמת לא חשובה לו, וזה לא קשור רק לעניין של האנטישמיות, זה קשור לזה שאנחנו חיים בעולם דיגיטלי, שבו הרשתות החברתיות מרוויחות הון עתק מאי סובלנות ומשיח מאוד מאוד אלים, ומזה שהרגשות הן חשובות יותר מאשר האמת, ולכן יש את התמונות האלה, ולכן יש את השיח הזה גם בכל מה שקשור לישראל. השאלה שלך היא שאלה גם מאוד מאוד עקרונית, כי אי אפשר בשם הסובלנות לבצע סובלנות כלפי קבוצות שהן לא סובלניות. וזה בעיה דמוקרטית, שגם בשיח על כל מה שקשור לקבל זרים, לא לקבל זרים, בגרמניה ובכל אירופה ובכל המעבר היא בעיה שמנסים לענות עליה באופן חד-ממדי. אני בעד לקבל מהגרים, אבל אם אנחנו מקבלים מהגרים ואין לנו את היכולת ומשאבים לגרום להם להשתלב בתוך החברה הגרמנית למשל, אם אנחנו מקבלים אנשים ואנחנו מדברים על ההיסטוריה של גרמניה, כן? אנחנו, מרקל ב-2015 אמרה, זה משהו שאנחנו מבצעים בגלל העבר שלנו, ואז לקבל אנשים ובכלל לא להשקיע אנרגיה לגרום להם להיות חלק ממערכת הערכים. אי אפשר בשם הסובלנות לקבל אנשים שמגיעים ממדינות מאוד מאוד אנטישמיות ולחשוב שבזה אנחנו מבצעים את החלק שלנו, ההיסטורי שלנו. זה לא יעבוד ככה. וכל מה שקשור לשוויון בין המינים, זכויות הלהט"בים, הבעיה עם האנטישמיות והרבה מאוד בעיות קיימות בגרמניה בקשר למהגרים, בגלל שאנחנו כמדינה לא הצלחנו באמת להציע אסטרטגיית שילוב לאנשים האלה, שהיא מעבר לעבודה ושפה, אלא להיות חלק מקבוצה שיש לה ערכים משותפים, והיא לא קיימת, ובגלל יש לנו את הגטוס ואת החברות שקיימות במקביל לחברה הגרמנית, וזה לא משהו שהולך לעבוד בעתיד. ולכן צריך תשובה, והתשובה היא לא קיימת, בעיקר לא קיימת במפלגות דמוקרטיות, ומי מנסה עכשיו לעשות את השיח על העניין, זה בעיקר מפלגות ימין קיצוני ושמאל קיצוני. ושני המפלגות האלה, שני השיחים האלה, הם שיחים שמאוד מאוד מצליחים ברשתות החברתיות, ולכן הם מקבלים כוח פוליטי אדיר, שאמור להדאיג אותנו בכל העולם, לא רק בישראל, לא רק בארצות הברית ולא רק בגרמניה.
אבל אני שומעת מהלא שלך, מה לא, גם את מה כן צריך לעשות, ואני חושבת שבטח אם אתה אומר שאין דרך לברור אנשים על בסיס ערכים או משהו כזה, וגם אני לא מצאתי דרך כשניסיתי לחשוב על זה אתמול בבית, אז כמו שאתה מציג את הדברים, התשובה בעצם השלכות הסובלנות זה להגיד בוא לא נהיה סובלניים, בוא נסגור את השערים שלנו בפני קבוצות מסוימות, כי יש לנו עליהם באמת איזשהו זיהוי שהוא הרבה פעמים יהיה נכון, אבל גם בסופו של דבר נראה לי שהליברליזם מקדש את הפרט, ואת זה שלא כולנו אותו דבר רק לפי המקום שממנו באנו. ואולי דווקא חלק מהאשמה לפחות היא לא על המאיימים, אלא על מי שאמור להתגונן בפני האיום. כי אתה אומר, שילמנו מס שפתיים בזה שהכנסנו את האנשים האלה לגרמניה, לצורך העניין. יצאנו ליברליים ונאורים, אבל אז לא עשינו שום דבר. ואנחנו יודעים שהאנשים האלה משתלבים במקצועות עם שכר יותר נמוך, ושכל בעצם הבידוד הזה מושתת על סיבות כלכליות חברתיות. אולי צריך להשקיע יותר בשילוב שלהם.
טוב, אני ממש לא מסכים איתך. אבל עכשיו אני מרגיש שאני מדבר עם עיתונאי שמאלני בגרמניה, שמנסה בעצם לעשות את השיח הזה על נושאים אחרים לגמרי, שמאוד נוחים, הם נכונים, אבל זה השאלות הנוחות, זה הסיבות הנוחות. יש סיבות אחרות, שאת מקבלת אנשים שמגיעים מסוריה, שהם גדלו במדינה, שהיא נמצאת במלחמה עם ישראל, שהם חושבים שיהודים וישראלים אין להם את הזכות להתקיים בו, אז את לא יכולה לצפות שהם פשוט נכנסים לגרמניה ועכשיו הם מתחילים להיות חלק מהאחריות ההיסטורית של גרמניה. זה לא קיים, אנחנו רואים את זה ברחובות מזה שנתיים. אני לא חושב שהתשובה היא 0 או 1, אני לא חושב שלקבל או לא לקבל. התשובה היא כמה מדינה יכולה בעצם לקבל בתוך שנה, אנחנו צריכים גם אנשים עובדים, ובאיזה דרך הם נכנסים לגרמניה. היום בשום הסובלנות מחליטים כל מיני עבריינים מי יקבל בכלל פליטות בגרמניה. זה אנשים שיכולים לשלם את הכסף, המשפחות שלהם יכולות לשלם את הכסף והם מגיעים בצורה לא חוקית מאפגניסטן ומעיראק וסוריה לגרמניה ולאירופה. צריך פשוט דרכים אחרות כדי לאפשר לאנשים להגיע בצורה חוקית לגרמניה. ואם אני יכול להסתכל על המרחב שלי ולראות שהחברה הגרמנית יכולה לקלוט אולי 200,000 אנשים, זה לא המספר, אבל 200,000 אנשים, לקלוט אותם זה אומר לתת להם ללמוד את השפה מהר מאוד, לתת להם לעבוד, כי יש המון אנשים שמגיעים ופשוט יושבים כמה שנים, שהם יקבלו איזו דירה שהם יכולים לחיות בכבוד, ובעיקר להעביר להם מה מצופה מהם בגרמניה. ומה מצופה מהם? מצופה מהם שהם יהיו חלק מהתשתית החוקית שנמצאת פה, ולהיות חלק מהערכים הבסיסיים שיש בגרמניה. אני לא חייב לחגוג את חג המולד כדי להיות גרמני, אבל אני לא יכול לצאת לרחובות ולהגיד from the river to the sea, ולהגיד זה זכותי להגיד את זה. זה לא מסתדר עם הערכים הבסיסיים של גרמניה. ואת השיח הזה צריך לנהל. ועל השאלה המאוד ספציפית שלך, אנחנו רואים למשל בעבודה שלי שיש המון אנשים בגרמניה, בעיקר צעירים, שמקצינים. הם מקצינים לכיוון שמאל, לכיוון ימין, לכיוון האסלאמיסטי, וכל התהליכים האלה מתרחשים, למשל בעניין של הרדיקליזציה האסלאמית, הוא לא מתרחש במסגד. זה היה לפני 10 שנים, הוא מתרחש ברשתות החברתיות. ואני שואל את עצמי, כמישהו שמנסה למנוע את ההקצנה הזאת, מה התפקיד שלי? התפקיד שלי היה עד היום ללכת לבתי ספר, ללכת לבתי סוהר, לנסות לדבר על האנשים האלה, להביא אנשים אפילו מהחברה של המהגרים, שיהיו דוגמה אישית לאנשים האלה, ואני חושב שהמקום הכי חשוב בעתיד זה ללכת לרשתות החברתיות ולנסות לעשות עבודת מניעה בזה שאנחנו נופיע עם השמות שלנו, נופיע עם הפרצופים שלנו ונגיד שזה לא בסדר, ולא לתת לאנשים האלה להיות ציד מאוד פשוט לאיזה אנשים מהימין הקיצוני או מהשמאל הקיצוני. וזה משהו שעדיין כמעט ולא מתרחש בגרמניה, עדיין ולא מתרחש, וגם ההסברה שלו קיימת בקשר לישראל, להגיד את האמת, לנסות להשיג את האנשים, וזה בעצם אחד הדברים המרכזיים שאירופה, שהמערב חייב לנהל בשנים הקרובות.
זה מעניין מה שאתה אומר, כי יש אולי איזו הקבלה, אמרת קודם על גרמניה נתנה לאנשים להיכנס, אבל בעצם לא עד הסוף דאגו שהם ישתלבו, וזה קרה בדרך לא דרך, באופן לא חוקי, בהעלמת עין. וגם כאן במישור הישראלי, אני חושבת שגרמניה היא אחת המדינות שהכי עמדה לצד ישראל לאורך המלחמה, גם כשמדינות אחרות הפנו לנו גב, ועדיין אתה אומר, זה אולי ההצהרה שלהם, אבל הם לא מסבירים אותה ככה שהבן אדם ברחוב יוכל מספיק להבין למה בעצם זה ביניהם הדבר הליברלי ולמה אנחנו בסדר, עם כל הקושי בדבר, עם כל מה שאנחנו רואים ברשתות החברתיות. ואם...
אולי שני דברים מאוד מאוד קצרים לעניין. קודם כל, גרמניה היה לה פוליטיקה מאוד מאוד ברורה, ואני לא ראיתי פוליטיקאי אחד, היה פוליטיקאי אחד שהופיע עם השם שלו ועשה וידאו קצר אחרי השביעי לאוקטובר ואמר זה מה שאני מצפה מכם. זה לא היה. אנחנו לא ביצענו את השיח הזה. והדבר השני והוא הרבה יותר חשוב, שאת מקבלת את האנשים האלה, האחריות להשתלבות שלהם היא לא רק הממשלה של גרמניה, זה אחריות אישית של האנשים שמגיעים לשם. זה אומר שאם יש לי ממשלה בגרמניה שאומרת מהשביעי לאוקטובר, לאנטישמים אין מקום בגרמניה, לאנטישמים אין מקום בגרמניה, ופחות מ100 מטר מהבית של הקנצלר או המשרד של הקנצלר, מופיע כל ערב מאות אנשים, מאות פלסטינים, שיוצאים לרחובות ואומרים מי שיש לו רובה, שיתן אותו לחמאס או יהרוג בו יהודים. האנשים ברחוב והאנשים באופן כללי, הם רואים שלאנטישמיות יש מקום מאוד מאוד גדול. זה אומר שאני מצפה מהממשלה לא רק לדבר ולא רק להגיד, ואחרי כל פיגוע יש דברים מדהימים שהפוליטיקאים מדברים עליהם, אלא לבצע איזה משהו כדי שהאנטישמים ירגישו שהם לא רצויים בגרמניה, וזה לא יתרחש.
אז אני חושבת שזה בדיוק מחבר אותנו למה שבן דרור אמר קודם, שכדי להילחם בתופעה הזאת לא מספיק לדבר, צריך ממש להוריד את הכפפות. ובואו נצלול רגע לפתרונות. מה אתה מציע בשם המאבק הזה, שהוא באמת מאבק חשוב על הזכויות הליברליות, איפה אפשר להיות לא ליברליים?
כן, זאת דילמה שבעצם כל חברה דמוקרטית, עד כמה אנחנו יכולים להיות סבלניים למישהו בלתי סבלני. זאת אומרת, מה עושים? יש את התשובה הידועה יותר של ג'ון רולס, שאומרת, כן, נהיה סבלניים, אלא אם כן יש סכנה קרובה ומיידית, משהו כזה. לא בטוח שאני מצטט במדויק, אבל זה פחות או יותר הכיוון שלו. אבל יש בעיה. זאת אומרת, לא תמיד הסכנה היא קרובה ומיידית, אז מה אתה עושה? אז בגלל שהסכנה תהיה לא בעוד שבועיים, אלא בעוד שנתיים, אז אני אתן, אבל אני יודע שבעוד שנתיים יהיה רצח. האמת שהזמנים עכשיו מצטמצמים. זאת אומרת, מה שנאמר במערכה הראשונה היום, הסתה, אנטישמיות, הדברים שמנצור מדבר עליהם, תוך שבועיים, זה מתרגם לרצח. עכשיו, מה אנחנו עושים איתם, ריבונו של עולם? מה אנחנו עושים עם אלה? זאת אומרת, אנחנו מצד אחד, ברגע שאנחנו מדברים על הגבלות, כמו שמנצור מדבר, רגע, סליחה, ספר שלם כתב על זה ליאב אורגד, גם לרוב יש זכויות, גם לאתוס המשותף יש זכויות. אנחנו לא רוצים שמישהו יבוא ויהרוס לנו את הכל. מה אנחנו עושים עם אותם אלה שבאים ואומרים בגלוי, בצורה הכי ברורה? אנחנו באים לכאן כדי להרוס את מה שיש כאן. עכשיו, מה אתה עושה איתם, ריבונו? עכשיו, אם אתה פותח את הפה, אז במשטרת המחשבות של הפוליטיקלי קורקט, אסור לך להגיד את זה בכלל. אסור לך לומר בכלל שכאילו יש בעיה. עכשיו, לך תסביר, לא, מה פתאום. לא מנסור ולא אני, אנחנו לא נגד כשמדובר באירופה. לא, זה לא הסיפור של ההגירה, זה הסיפור של אלה שמתנגדים לעצם קיומו של האתוס המשותף, הליברלי, הדמוקרטי, הסובלני. מה אתה עושה איתם? מה אתה עושה איתם? זאת אומרת, כאילו, עכשיו, אז אמרתי מקודם, הליברלים חייבים חשבון נפש, הליברלים חייבים חשיבה מחדש, הליברלים חייבים לומר, די, מספיק. זאת אומרת, כאילו, עם כל הכבוד לכל הכללים הישנים, והמנוסחים יפה בפסיקות שאני יכול להסכים עם חלקן, לא להסכים, זה לא חשוב כרגע. אני אתן דוגמה קונקרטית דווקא מישראל. יש לי מחלוקת גדולה עם בית המשפט העליון, שאישר את המועמדות של בן גביר לכנסת. לי נדמה שזה היה ברור, היה אמור להיות ברור. לי היה ברור לפחות שאנחנו פותחים פה פתח למשהו איום ונורא. והנה זה מתממש. והנה זה מתממש. אז ריבונו, את שואלת על אמצעים? כן. הדמוקרטיה המתגוננת חייבת להיות קצת יותר מתגוננת. אם להרגיז, אז קצת פחות דמוקרטית וקצת יותר מתגוננת. למה? כי זה היה אמור להיות ברור שזו סכנה אמיתית לדמוקרטיה, ואנחנו רואים את זה עכשיו מתממש. כשאתה נותן כוח לקבוצה קיצונית רדיקלית, בשם חופש הביטוי, בשם הערכים הנפלאים שכולנו מאמינים בהם, הם מנצלים את זה בצורה הפוכה. לא צריך ללכת לאסלאמיסטים בגרמניה כי זאת דוגמה, או באירופה כי זאת דוגמה קלה. אני נותן את הדוגמה שלנו, אצלנו. הנה, הם קיימים בתוכנו והם חותרים נגד עצם קיומה של הדמוקרטיה הליברלית שאנחנו רוצים להיות. אז אם היינו מגבילים אותם, אז היו פחות תופעות. האם יש כוח? הנה, היה כאן דיון מאוד מעניין. האם לבתי משפט כן או יש כוח להגן על הדמוקרטיה? לא תמיד יש, השאלות כפי שעלו כאן גם בדיון הן לא פשוטות והן לא שחור לבן, אבל עדיין באותם מקומות שבהם החוק המפורש אומר צריך למנוע כניסה של גזענים לכנסת, חבל שבית המשפט, אני מצטער על כך שבית המשפט לא מימש את החוק ככתבו וכלשונו, אלא מצא כל מיני פרשנויות כדי לאפשר לגזען, לארכי גזען הזה להיכנס, כאשר הסכנות היו ידועות מראש. הנה זה קרה, כן, הנה תקשי עליי.
אני אומרת, בסופו של דבר, גם ראינו את זה בעוד פסיקות של בית המשפט העליון, הרוב בחר בו, הוא לא היה שר עדיין בעת שנעשו הפסיקות, בעת שהוגשו העתירות לפחות, סליחה. האם עדיין אפשר לקרוא לעצמנו דמוקרטיה ליברלית? אם היינו פוסלים בן אדם שכל כך הרבה אנשים בחרו בו, מלשרת את הציבור?
שאלה מצוינת, כאילו אני הולך לרמת העובדות, ברמת העובדות ב-2019 הוא קיבל 0.5%, הוא לא עבר את אחוז החסימה, הוא היה משהו מאוד קטן. היום הוא כבר נמצא, הוא מתקרב ל10%. ואני שואל את עצמי, רגע, אנחנו עשינו את זה. אנחנו עשינו, במו ידינו. אנחנו, בשם אותם ערכים נפלאים שכולנו תומכים בהם, עשינו את זה. אז יכול להיות שאנחנו צריכים את ההתבוננות, עכשיו זה קצת מאוחר, היום לפסול אותו זה על סף הבלתי אפשרי, בגלל שהוא כבר צבר כוח, אבל איך אומרים, את הדברים הקטנים האלה צריך להרוג כשהם קטנים. לא הרגנו אותם כשהם קטנים, אנחנו תופסים עכשיו חיה. אז כן, אז בעניין הזה אני חייב לומר, דיברתי על הסכמות עם כבוד הנשיא לשעבר אהרן ברק, בעניין הזה יש בינינו כנראה חוסר הסכמה, ביני לבין חלק מהשופטים שפסקו כפי שפסקו, יש בינינו חוסר הסכמה, כתבתי את זה גם בזמן אמת, זה לא שאני אומר את זה עכשיו, אתם טועים, אתם מכניסים מפלצות לכנסת, לצערי אנחנו היום משלמים את המחיר על זה, אבל אני חושב שאנחנו עדיין חברה חזקה, אנחנו עדיין למרות הכל, אני חושב שעדיין יש מקום לצעדים בכיוון הזה של דמוקרטיה מתגוננת, כדי לא לתת למפלצת הזאת להיות הרבה יותר גדולה, כי היא תחסל אותנו.
אז זו הייתה תשובה ככה לאיפה באמת אנחנו אולי צריכים לשנות את הדפוסים שלנו, אולי אפילו טיפה להתרחק מהליברליות כדי לשמור על חברה ליברלית, אבל אני רוצה לסיום לשאול אתכם דווקא על הצד השני של המשוואה. האם יש איזה שהם כלים שהם כן ליברליים, שאנחנו יכולים להפעיל, שאנחנו יכולים לעשות יותר, על מנת לעצור את התרחבות התופעות האנטי-רדיקליות? האם יש דרך להבטיח זכויות מסוימות, גם אם קבוצה אחרת נהיית הרוב. איזשהו מנגנון שבעצם לא נעשה היום, שיכול להתמודד עם מצבים כאלה, כי אנחנו יודעים שהאיומים האלה, דמוגרפית אפילו, רק ילכו ויחריפו.
שאלה מאוד מאוד חשובה, לא בטוח שיש לי את התשובה, ואני אגיד את זה באופן מאוד אישי. עוד כמה דקות, אז יש הפסקה. הבת שלי בת 11, ואני עושה איתה כמעט כל יום שיעורי בית. ואני שואל את עצמי, אני הייתי בשנות ה-80, תחילת ה-90, בבית ספר בטירה משולש. והבית ספר שלי היה ממש אחרת. הייתי צריך ללמוד עברית, ערבית, מתמטיקה. וכשאני יושב עם הבת שלי, היא שואלת אותי כל הזמן, למה אני צריך ללמוד את זה? אני יכול לפתוח את הזה, ויש לי את זה עם הקאי בתוך שניות. ואני שואל את עצמי, מה הילדה הזאת צריכה בגרמניה כדי להצליח בחיים? ומה שהיא צריכה זה משהו ממש אחר ממה שהייתי צריך. אני שיחקתי בחוץ. הילדה שלי הולכת לגדול בעולם דיגיטלי. אנחנו מסתכלים על גרמניה גם מבחינה פסיכולוגית, ואנחנו רואים שהיכולת האמפתית של הילדים נשחקת, וזה מסוכן. זה אומר שהבית ספר וההורים צריכים להעביר לה את היכולת האמפתית, כי האמפתיה זה החיסון נגד הקצנה דתית והקצנה מכל סוג. דבר שני, הילדה שלי צריכה ללמוד להסתדר עם הידע, לא להרוויח ידע, אלא איך אני יכול לדעת אם הדבר הזה הוא אמת, אם זה פייק ניוז, אם זה דיסאינפורמיישן, זה הולך להיות מאוד מאוד חשוב בעתיד, והבתי ספר לא מצליחים להביא להם את זה. אם אנחנו רואים שהשימוש ברשתות החברתיות הורסת את היכולת, את הסבלנות לעמימות, את היכולת לקלוט שאנשים אחרים יש להם דעה אחרת, אז הבית ספר צריך להיות מקום שבו מתנהלים דיונים פוליטיים, שאנשים ישימו לא את הרגשות, אלא את הפקט באמצע, וזה אומר שאנחנו חייבים מערכת חינוך אחרת, שתתן לילדים את היכולת להסתובב במרחב דמוקרטי, ליברלי, ולהישאר דמוקרטיים וליברליים. הילדים של מהגרים סורים, שהגיעו ב-2015, שגדלו בגרמניה, אני לא מסכים שהם הולכים להיות כמו ההורים שלהם, אם הם מבקרים בבתי ספר גרמנים שיש בהם מערכת אחרת לגמרי של ערכים בסיסיים שהולכים להביא לילדים האלה. לקבל מכות מהאבא זה פחות אטרקטיבי מאשר להסביר לילד שיש לו את הזכות כילד לחיות בלי שאף אחד ירביץ לו. והגרמנים או הרוב הם פשוט, בגלל שהם מפחדים להיות גזענים, הם לא מוכנים לעשות את הצעד הזה ולהגיד לילדים האלה, אתם יכולים אפילו להתקומם נגד ההורים שלכם, יש לכם את הזכות להיות אחרת בגרמניה. וזה דברים שאפשר וחייבים לעשות אותם, בעיקר בבתי הספר, כדי לדאוג לזה שיהיה לנו עתיד דמוקרטי, במרחב אחר לגמרי, שמשתנה לגמרי עם הרשתות החברתיות, עם הדיגיטליזציה ועם הקאי שמגיעה אלינו, וזה דברים שלצערי הרב, עכשיו מתחילים לדבר עליהם בגרמניה ובעולם בכלל, אבל היינו חייבים להתחיל את זה כבר אתמול.
ובן דרור, אותה שאלה, כי אגב מה שאמרת קודם על בן גביר כדוגמה, ברגע שאנחנו מתחילים להגביל, אני מניחה שיהיו ואנחנו כבר שומעים קריאות כאלה בעולם, שיגידו, כמו שהוא אומר על סוריה, הישראלים מגיעים משלטון של הערכים שלו, שיש לו התבטאויות ששמענו לחברי כנסת בפרלמנט, כמו לשטח את עזה, אז אולי אנחנו צריכים לא להכניס את כולם, ככה שזה מדרון חלקלק, יש דרך כן להתמודד עם זה בכללי משחק ליברליים?
שאלה מצוינת, כי קשה מאוד להגדיר את אותם קווים אדומים שאנחנו רוצים להגדיר. זה לא דבר פשוט, זה לא דבר שאני אצליח לעשות כשאני נמצא כאן. אני רק יודע שאנחנו אבל במצב הפוך. אנחנו במצב של חוסר רצון להתמודד. דיברת על חינוך בבתי ספר. בשנת 2004 פורסם בצרפת, ב-2004, דור קודם, דוח אובין, שכל כך קוראים אובין, אובין היה איש חינוך מאוד בכיר בצרפת, והוא דיווח על, פרסם דוח על בתי ספר, והוא דיבר שם על אותה תופעה שהיום מנצור מתמודד איתה, על האסלאמיזציה, ב-2004 בכלל. עכשיו, כאשר בעצם דור שני ושלישי, ושם מדובר כבר לגמרי בנייטיבס, לא כמו אלה שהגיעו ב-2015, ששם המצב הרבה יותר גרוע. והוא דיבר על זה. עכשיו, אז יופי יש דוח, ורק פסיכים כמוני שמתעניינים בנושאים האלה מפשפשים ומוצאים את כל אחד והסטיות שלו. אבל מה קרה עם הדוח הזה? אפס, כלום. למה אני אומר אפס כלום? כי לפני חודשיים פורסם דוח דומה שאומר, אוי, המצב איום ונורא. כמה אנשים שמעו, אתה בטח שמעת על זה, אבל כמה אנשים שמעו על הדוח הנוסף שפורסם לאחר 20 שנה. גם, זאת אומרת, כאילו איכשהו, הוא נגנז, הוא פשוט נגנז. כי הדוחות האלה פשוט, זאת אומרת, כאילו, אנחנו נמצאים בפני דיסוננס קוגניטיבי. החברה הליברלית באשר היא לא אוהבת את הדוחות האלה, כי זה סותר את עקרונות היסוד של החברה הדמוקרטית. ואנחנו אומרים לעצמנו, לא יכול להיות, כי כל מה שלא מתאים לנו לא קיים בעצם. ואנחנו מדחיקים אותו. אנחנו כבני אדם לא אוהבים להיחשף לעובדות שמטרידות אותנו, שלא תואמות את השקפת עולמנו. הליברלים קוראים את הניו יורק טיימס, ולא במקרה כי זה נוח להם, והשמרנים קוראים את הוול סטריט ג'ורנל, כי זה יותר נוח להם. אנחנו לא אוהבים, וכאשר מגיע כזה דוח מאיש חינוך בכיר, פשוט מה עושים? זאת אומרת, כאילו לא מתאים להשקפת העולם, לא מתאים לאג'נדה הכוללת שלנו, אנחנו שמים אותו בצד. וזה המצב שבו אנחנו נמצאים. אז אנחנו, כאנשים שרוצים חברה דמוקרטית, הפתרון שלי, חברה מתגוננת, אמרתי את זה, נדמה לי שאני חייב לומר את זה שוב, כדמוקרטיה מתגוננת, קצת יותר מתגוננת. זאת אומרת, הכללים שקבענו לעצמנו עד היום לא טובים, פשוט לא טובים, לא בגרמניה, לא בצרפת, לא בישראל, הם לא טובים, הם לא נכונים, טעינו, קשה להודות בטעות, וזאת הבעיה, קשה להודות בטעות. אנחנו כליברלים מתקשים להודות בטעות, אנחנו חוזרים על אותן סיסמאות כל הזמן, שאומרים, לא, הנה אנחנו שומרים, לא, אנחנו לא שומרים על שום דבר, אנחנו פותחים פתח לדברים איומים ונוראים, כמו שאנחנו רואים אותם בגרמניה, כמו שאנחנו רואים בישראל, בואו נודה. כשאני רואה מה עושים אותם נערי גבעות, שיש להם גיבוי מהממשלה, שידם הארוכה והאיומה מגיעה ליפו, עם מה שקרה שם רק בשבוע שעבר. אז אני אומר, רגע, אנחנו כל כך סובלניים וכל כך סלחניים וכל כך נחמדים וכל כך טובים וכל כך ליברליים, אבל זו התוצאה. וזו התוצאה, ואת התוצאה הזאת אנחנו חייבים להיות הרבה יותר זהירים, הרבה יותר פותחי עיניים, כי סגרנו את העיניים, כי התמכרנו לדברים, לאג'נדה של עצמנו, ולא ראינו שהסכנה הרבה יותר רצינית ממה שהיה נדמה לנו. אז כן, צריך לשנות את הכללים, קצת פחות, הנה אני אגיד את זה בצורה ברורה, קצת פחות ליברלים כדי לשמור על הליברליזם.
טוב, אני שם לב שגם בהרצליה יש בועה, ואני מסכים עם כל מה שאתה אומר, אבל אני רוצה להדגיש שזה משני הצדדים. יש נושאים מאוד מאוד נוחים, גם בגרמניה אפשר לדבר על המלחמה בימין הקיצוני בצורה מאוד מאוד קלה, ולא צריך שמירה משטרתית שעושים את זה. ברגע שמדברים על הדוחות שאתה מדבר עליהם, בכל מה שקשור לאסלאם הפוליטי, בכל מה שקשור לבעיות של אסלאם רדיקלי, אז יש בעיה. זה לא נוח, כי זה לא political correctness. ושאנחנו מדברים...
אתה חייב להסתובב בגרמניה עם שומר.
כן.
למי שלא יודע.
ושאנחנו מדברים... טוב, שאנחנו מדברים על בן גביר ועל נערי הגבעות, אני מסכים אותך ב1,000,000%, אבל אנחנו צריכים להסתכל על הצד השני. ובצד השני יש את איימן עודה ואת אחמד טיבי, שהם גם לא חלק מהשיח הליברלי במדינה דמוקרטית.
אז לצערי נגמר לנו הזמן, כי באמת מרתק לשוחח איתכם, ואני רק אגיד אולי לסיום אם יש משהו שכל אחד אולי יכול לקחת מהשיחה הזאת, כי אנחנו שמענו שהמדינות ברמת המדינה לא עושות מספיק, וראינו שרוב הכלים והדברים נמצאים ברשת, ואגב, גם לנו, כתקשורת ממוסדת, יש אחריות בכל מיני סוגים של סיפורים, לתת משקל זה כשמישהו יוצא זכאי ונחשד וכולי. נסו לחשוב איפה כל אחד מכם אולי יכול טיפה להיאבק בזרמים האלה בכלים ליברליים יותר או פחות, אבל כדי לשמור על הליברליות.
We will now take a 15-minute break and then return for additional fascinating sessions. After the break, we continue with a session on checks and balances and judicial independence. And everyone with a translating device, please bring it back to the booth there. I am honored to invite Dr. Marco Buschmann, former Minister of Justice of Germany. Following Dr. Buschmann's remarks, we will hold a conversation between former Ministers of Justice of Germany and Israel.
Well, ladies and gentlemen, it fills me with profound gratitude to have the opportunity to address this conference. This gratitude is, of course, directed toward the many people who made this conference possible, and I think it's worth an applause, an extra applause. Thank you so much. But it is directed above all toward the occasion itself. 60 years ago, Israel and Germany established diplomatic relations for the first time. After the Shoah, the country of the victims was willing to speak officially with the country of the perpetrators about a shared future. In the wake of the greatest crime in history, this was surely one of the most generous gestures history has ever witnessed. It was this extraordinary gesture that allowed trust to grow and, in time, true friendship to flourish. And I'm personally deeply thankful for this remarkable journey, and the overwhelming majority in my country feels the same heartfelt gratitude. A hallmark of true friendship is the ability to speak frankly with one another. In Israel, you say tacheles. When I visited Israel in an official capacity as minister in 2023, I met with Israel's Minister of Justice, Yariv Levin. We spoke with remarkable candor for more than twice as long as originally scheduled. And our conversation revolved around fundamental questions of the rule of law, the planned judicial reform in Israel, and the role of the judiciary within a system of checks and balances. And today I would like to speak once again about precisely that, the role of the judiciary in a liberal democracy. First, I want to share some thoughts with you about the relationship between democracy and the rule of law. We heard already some things about that, but I would like to stress it a little bit more. For several years now, there has been an effort to separate these two principles from each other. Democracy is taken to mean that in cases of doubt, the majority may decide everything. The rule of law, by contrast, places limits on the majority. It therefore stands in a relationship of tension with democracy. That's the argument. And when push comes to shove, the principle of democracy is deemed more important than that of the rule of law. And since the rule of law is firmly bound up with the concept of liberal democracy, some have been gone so far to champion an illiberal democracy. If one were to ascribe a pithy slogan to this school of thought, it might run as follows: democracy is the rule of the people and not the rule of the judges. It is my conviction that this school of thought rests on a fundamental misunderstanding of the democratic principle. The philosopher Karl Popper once remarked of democracy that its core lies in the ability in the people's ability to get rid themselves of a government at the ballot box without having to resort to arms. If one accepts this as correct, it follows with logical necessity that a minority must have the opportunity to become a majority, so that democratic opposition can turn into a new government that replaces the old one. For how else could the people get rid of their government if they wished? Yet a minority has a fair chance of becoming a majority only under certain conditions. The right to democratic opposition, freedom of speech, freedom of the press, and open-ended elections. In short, the classic fundamental rights of liberal democracy. And to ensure these conditions, to ensure that these conditions are protected, an independent and robust judiciary is required, one that effectively safeguards the classical fundamental rights of liberal democracies. If I may state my position in pointed terms, it is this: democracy is liberal democracy, or it is no democracy at all. Now you can perhaps imagine why the meeting with your Minister of Justice back in 2023 lasted so long. However, I assume that most people here think much the same way I do. If I were to stop my train of thought at that point, this wonderful event might turn out to be a little bit boring, so that we might engage in a bit of more genuine debate. I would like to go a little bit further. As proponents of liberal democracy, we have to ask critically ourselves, why are proponents of illiberal democracy winning elections with increasing frequency? I raise the question because, in my view, some usual answers with which we content ourselves are unconvincing and do little to move us forward. I want to illustrate this with two examples. First, take the familiar claim that the competition between illiberal and liberal democracy is unfair. Proponents of illiberal democracy, it is said, resort to populist methods, and populism often offers simple answers to complex questions. And for that reason, the argument goes, it is more popular because it is easier to grasp. I think you are quite familiar with that argument. Frankly, that is a helpless argument in democracy. Democracy means competing for majorities, and that in turn means persuading the public. Anyone familiar with the practice of public speech knows that an argument must be capable of being stated simply. That is no intellectual humiliation. Think of the world-famous physicist Richard Feynman. He said that if you cannot explain something in a very simple way, then you have not truly understood it. Complex jargon is not evidence of expertise, but often facade. Put differently, even someone who has a complex answer to a complex problem must be able to explain it in simple terms. Anyone who cannot or refuses to do so is a snob. And snobs fare poorly in a democracy. We must not be snobs. Otherwise, we make life very easy for the populists of illiberal democracy. Second, take the reference to foreign propaganda. In Europe, it is very popular to argue that public opinion is manipulated by such propaganda. And the point is not wrong. We know such activities exist, and they must not be underestimated. Of course, Russia and other foreign powers have an interest in destabilizing liberal democracies, and they possess effective techniques for doing so. That's true. However, we must ask why this propaganda finds such fertile ground today. There was such propaganda of this kind even during the Cold War. Back then, too, it claimed that the democratically elected governments of the West were corrupt or enemies of the people, and that the judiciary was part of an ideological superstructure designed to oppress the populace. Yet these formulas found little resonance at that time. They were far from influencing electoral decisions in any meaningful way. Why is it different today? We have to ask ourselves, why is it different today? I think, that's my personal view, that a substantial part of the answer is that a substantial part of the public in liberal democracies is under the impression that the system is no longer capable of adapting to a changing world. For example, the global shift of wealth from the West to the East, the extent of migration, or new security threats. At least I can say that about Germany. In cybernetic terms, we have so far lacked the ability to adapt quickly to radically changing environmental conditions in the eyes of such substantial part of the public. This is certainly also a lack of leadership. Certainly, this is also a problem of political parties, because I know it myself, political parties like to immunize against change, because change is always hurting, painful. But the question must also be asked whether constitutional jurisprudence has contributed to this felt lack of adaptability. I know that hurts as fans of liberal democracy, but we have to ask ourselves, what could we do better? Perhaps one could advance the thesis that in the 1990s and even after the turn of the millennium, many were convinced that the end of history in Fukuyama's sense, that we have the end of history in Fukuyama's sense. The major fundamental question of politics seemed to have been definitely settled. Politics appeared to have nothing left to do but fine-tuning. Environmental conditions seemed very stable. Politics as a regulator of diminishing variance itself seemed to require less variance, less room for maneuver for effective governance. So I have to give this in. The organizers tell me that I have not the 15 minutes. I thought I have just 10 minutes, so I will crash the schedule now. It's totally my fault. But I want to complete the argument. Against this background, it seemed plausible to further restrict the room for maneuver of day-to-day politics by means of constitutional law arguments. And perhaps in this way, part of what constitutes the flip side of a strong and independent constitutional judiciary was lost, namely what the US constitutional tradition calls judicial self-restraint. It may therefore be the case that constitutional courts acting in good faith, they didn't want to do something bad, in good faith, have narrowed the room for maneuver of responsible politicians too far, leaving them scarcely able to implement changes that are necessary or legitimately demanded by a substantial part of the public. That in turn would mean that even a new government replacing the old one would be unable to implement the changes that are actually required. And this is a propaganda bonanza for the populists, because they frame it as the ultimate proof that so-called mainstream politicians are incompetent or dishonest, because they do not deliver what they have promised to do after the elections. Let me give an example from Germany in the area of welfare policy. For many years, there was an accepted principle, the so-called wage distance principle. The German term is Lohnabstandsgebot. You hear we Germans love long, long words. It held that social assistance should be set at a level that maintains a sufficient gap vis-à-vis the lowest wage groups. Put differently, it had to remain below market income. Social assistance had to be below market income. One day, the German Federal Constitutional Court declared this unconstitutional. The level of social assistance, it held, must be determined abstractly without reference to the lower wage groups, and must moreover be adjusted for inflation. You may think that's right or not, that was the ruling. This led to outrage, particularly within the lower middle class, for two reasons. First, people there consider it unfair that someone who does not work receives more money from the state than another person earns through their own labor. Second, in times of higher inflation, social benefits regularly grow faster than wages in the lower middle class. That's why these people were outrageous. Politicians who promise change on this issue during election campaigns and are elected on this basis later find themselves stemming to this case law. This is currently being experienced by the new German government, which promised a reform of social assistance, but will likely not get beyond cosmetic changes. As a result, it will probably be attacked by populists as incompetent and dishonest. And pointing to the Federal Constitutional Court will not make the court any more popular either. Perhaps we need to strengthen once again the idea of judicial self-restraint in a time marked by high variability in environmental conditions, and thus one that calls for greater variability in the room for maneuver of responsible politics. To sum up, responsible politicians either solve problems or the problems will seek out new majorities. If all responsible politicians lack the room for maneuver to solve those problems, the problems will produce majorities for irresponsible politicians, and that is something no one should want. This is the idea behind judicial self-restraint. Constitutional adjudication must be strong and independent within a system of checks and balances, but it must not constrain the democratic process to such an extent that it becomes dysfunctional. Otherwise, it plays into the hands of the enemies of liberal democracy. Thank you so far.
We will now continue to the panel. I am honored to invite Advocate Dan Meridor and Professor Daniel Friedman. The discussion will be moderated by Professor Iris Canor, Faculty of Law, the College of Management, Academic Studies.
Thank you very much. My name is, as I was presented already, Iris Canor. I'm professor of international law and European law in the Tzfat College, but also in the College of Management, also at Tel Aviv University. But I'm also familiar with the German legal system because I'm also working for the Max Planck Institute in Heidelberg, which is for international and European law. So I'm very honored to be here, and I think we will jump directly to the water. So I constructed the whole debate differently, but I want to pick up with the last remark that you said. You said that the judges should be more self-restrained. We heard from, I think what I heard from Aaron Barak before, is that courts should be able to live up to the job of protecting democracy, probably also being activists while doing that. So I think we have a problem of framing. You said yourself the problem is sometimes, at least in Germany, is the wealth movement. It's about immigrants, and it's about, what do we say? Security questions. Do you think judges normally frame interference in these questions by the protection of fundamental rights, the fundamental rights of the migrant, the fundamental right of those who are threatened by the security of the state? So, do you think that this framing is wrong, and really judges should avoid dealing with these questions and leave it to the majority to decide about the rights of these invulnerable people, or we should be in a different way? It's all for all of you. One of them.
Well, first, I think there is no dispute between Aaron Barak and me, because what he said is absolutely true. You have to protect the framework of the political process. If there is a party that says, well, we want to make a bill, for example, or an act that is unfair and infringes the competition between the democratic parties, judges must say, stop, that is unconstitutional, we have to protect democracy. But in the course of the last 10 years, there is a trend that sometimes people try to substitute a political debate by a constitutional law discourse. And the Constitution is our framework, but political questions have to be solved and discussed in a political way, to be more abstract. I gave you one example from welfare politics. Another example is climate change. It is a political question, it's an important question, and we should have lots of dispute and discourse about it to find the right way, what's the right way to fight climate change. But some lawyers in my home country say, no, it's not a political question because the Constitution says we have to protect the environment, and even our constitutional courts made a lot of detailed rulings on how to protect the climate, and I think that's a problem. The Constitution is a framework, and the framework must be protected boldly. But constitutional law cannot substitute a political discussion, and that's the point I wanted to make.
So just to push it a little bit harder. So the courts in Germany, but also by the European Court of Human Rights, they talk about protecting the environment in the sense of protecting either the privacy, but also the right of life of next generations, and impose on the states really obligations to dedicate money to this protection of the environment. So this framing, protection of fundamental rights of the next generations, you think it's a wrong legal framing?
I dislike the word framing, because framing is a propaganda technique. We are academians, we are scholars, we are lawyers, we have an argument or not. Framing is rhetoric or manipulation. So in my home country, people say, Marco Buschmann is a fundamental rights fundamentalist. So I'm not the one who says fundamental rights are not important. So that. But if we aim to strengthen fundamental rights sustainably over decades and periods of time, the public shouldn't come under the impression that we use fundamental rights because we are afraid of political discussions. And of course, privacy must be protected. For example, I was one against this, I don't know if you heard about, is this, how do you call chat control? Have you ever heard about chat control? That is a draft bill of the EU that aims to check each and every text message whether there is illegal content. And I was the one, it's not, so I'm an advocate for fundamental rights. But if you use the concept and say I can derive from a constitution a precise concept to protect climate change or anything else, then you substitute a political discourse by a legal discourse. And that leads to, that plays into the hands of populists, because they say they don't want to ask the people and they don't want to do with the people. They are intellectuals, they are able to interpret the law as they want. And that is a powerful argument to mobilize the public against the rule of law and constitutional courts. And Aaron Barak said something very important. The court cannot protect democracy against the people. We always have to fight that the majority of the people says, well, the rule of law is in our interest, against the powerful, against the mighty, against an unfair government. And we shouldn't accept a framing that says all these intellectuals in the universities, these elites, are using the rule of law to suppress the majority of things like that. I think this is nonsense, but it's used as a framing against the rule of law, and we should fight against it.
Thank you very much. So now back to my original question. So the first question I wanted to ask you all is, what do you think is the main legal challenge, constitutional challenge right now in Israel and in Germany that Israel and Germany is facing? If you only need to choose the main one, legally, it can be institutional, it can be values, it can be whatever you think is the right one. But the most important one, if you want already to answer also the next question, is do you really think that the court can help in confronting this main challenge of deteriorating democracies in Israel and Germany? Dan, you want to start?
Good evening, thank you for your lecture. I happen to agree with most of the things you've said. I think democracy is a challenge or under threat in the world that we know, in the Western world, the free world. And it has to do with the basics that were mentioned by you. This sentence by Mr. Orban of illiberal democracy is an oxymoron, a contradiction in terms. Because against the common understanding, democracy is not the rule of majority. Majority decides who the ruler is, but what the ruler's authority is a different question. Churchill had majority, Hitler had majority, Stalin had majority, Roosevelt had majority. These were Democrats, these were non-Democrats, because majority is not everything. It's a necessary condition, entirely not sufficient. And if we say that democracy is not only about who is the ruler, who is the government, and this is not a dynasty of a king, it's not a pope or a rabbi who decides, it's the people who elect by majority, this is fine. Then we know that we don't want to allow this majority by government or by parliament to take away from me certain rights. Not only about the change of government, which you mentioned. They can't take my property without any reason, without paying me. They can't arrest me in the street. All sorts of things. They may have majority. You will have a rule of majority, you want democracy. A good example may be against this concept that just let the people speak, you'll have democracy, may be seen in what we knew as the Arab Spring. 2011, Cairo, Tahrir Square, remember that? All the slogans were Western slogans, not Muslim. For democracy, for freedom, for responsibility, we loved them. And they were able to kick Mubarak out of office. And the people voted. And they voted for a party that does not want democracy. Women are not equal to men, the Muslim Brotherhood. People should not criticize the government. So rule of majority is a necessary condition, not the most important one. We need to, people, human beings are the core. We have states for human beings, not the other way around. We need to protect human beings against the majority arbitrary or wrong decisions. It's not easy, not always it's clear for black and white, but constitutionally and institutionally, the court's role, role has to do with that. It has to be independent, not enough. It has to stick to the basic values of democracy. The American court was very independent from 1776 to Lincoln. Blacks were not people and women didn't vote until 1920, I think. If the court agrees with the majority, you have no democracy, or not democracy you want. So we need the court to know that it's business, on top of deciding who is right and wrong on a contract or a road accident, to defend the individuals or minority groups against abuse of power by the government or by the parliament. And if the Constitution deals with that, and it should deal with that, we don't have a written Constitution, not a full one anyway. We tried, to do something, but we haven't been very successful in that. It is, in the end, the role of the court to make a decision to defend me against the government. I do agree that sometimes it's debated, but refraining from doing that by self-restraint may mean that they don't give me my remedy. And I think I deserve my remedy. The court should not take into account public opinion at all. Should not look for the nice words of the public or fear the ugly words. They should do what they think is right in that respect. If the court has to be elected or needs a public support, it will not be an independent court. Which is why in our country, until recently, judges were not elected by politicians, or not a majority of politicians anyway. I was in that committee that selects judges for 8 years, as Minister of Justice, as a member of the Knesset. We never had this discussion. We did not have any politics in it. I have to say we did not. There may be different opinions, different views, but it was not politics. If it turns to be as the law that passed and may come into effect in several months, we'll have a court that is entirely political. This, to me, is the most dangerous, if not fatal, blow to our democracy. The feeling of somebody who goes to court, that you have a judge that you may like or not like his decision, but he's impartial. Does not need the smile of the minister, or it does not need to be promoted by the minister, is crucial. And if he knows that this judge is from the other party, not my party, this to me is the end. So I think that the court role is not always easy. It is essential in democracy to defend those who don't have a majority. And as it relates to fundamental rights that we mentioned here, in Israel it's strange and very unique. Unfortunately, and against our history, we, in our basic laws, don't have the rule, the basic rule that every constitution has: all men are equal before the law. It does not agree because there was no agreement. I tried it. Men and women are equal. Are you crazy? Arab and Jew, gay and straight. This was the reason we don't have it. And thanks to the court's interpretation, they used the human dignity to say it's in it. But it's not the normal way. We don't have the freedom of expression. We don't have it. Only the court decided. By the way, it's not only the Constitutional Court. Think of it from day one, when the court was really active, not like today, deciding against the government on defense issues. Take the Kolam. They say you, the government, cannot decide on the balance between defense needs and freedom of speech. This paper will not be closed. They remember the 53 decision. Very courageous court. The difference now, and this is your question about the big danger, those basic agreed principles were really agreed by everybody in terms of institutions. We knew the rules of the game. When the Knesset decides, it's final. When the court decides, it's final. You accept it. And the basic values were accepted. Today, if I speak in public, I'm in politics now, for democracy, human rights, rule of law, I'm depicted as leftist, which, as you know, I was not. This was once the basic understanding of everybody. Now it becomes a partial issue. It's very dangerous. And as the courts are now being either mocked at or made to look as if they are political, this is very dangerous. And in Israel, we have equality because the courts decided we have equality, not because the Knesset shamefully never did that. We have freedom of expression because the court decided before the constitutional story. So I don't want to compare to Germany. We tried. The last thing I would say, I understand you spoke of Alternative für Deutschland earlier, sorry. Yeah, good. In our case, we had in 1984, a member of the Knesset was elected who was a racist. And from 85, we changed the law, the basic law, that somebody who incites racism cannot run. And we, the National Party called Likud, we collected all the materials this man published for 3 years. In 88, I brought 3 big cases to the court, and they banned him because you can't incite racism. Unfortunately, it was changed recently. I don't want to go to Israeli politics now. If racism becomes legitimate, where do we go? In a democratic state, and moreover in a Jewish state. The ultimate victims of racism. Shameful. So the basic things that were agreed by everybody are now under attack. Not the old Likud labor fights over reparation of Germany, over peace and land. It's the basic values that are now attacked, and the agreement of the principles and of the institutions. So we have a different kind of fight now, and we need to win it. Will it be a majority? Of course we need majority. But, and I agree, we need to be able to say things in a simple way, not in a complicated way, not easy. And last thing I would say, which I don't want to continue too long, there is something in those iPhones that everybody holds here. These iPhones, the smartphones, allowed a direct contact between the contender, pretender, whoever it is, and the masses without anybody in between. In old days, you needed, if somebody was elected, Minister of Health, he decides. But can you really deal with COVID without the epidemiologist? You need the knowledge, the science, the wisdom. Of course, he decides, but needs to consult with him, right? Or you go, as Mr. Trump says, I don't need generals to go to war. You need professional people. You decide, but you need to listen to them. Today, not only you don't, you despise them. Those with privilege who need them. Because there's a direct line. When you speak to the, forgive me the word, the masses, the people, in 5 words in TikTok, or in 10 words in whatever other thing, Twitter, you can't speak to the brains. You speak to the gut feeling. On their identity, not on the issue. And you may win elections. So we face a real change, a real challenge of technology that has allowed this direct line without anything in between. It might have been somebody that you may know better than us that have used the radio over the head of the intelligentsia of the Weimar Republic. Dangerous.
I would make first a few historical comments. We must remember that democracy is a system that is very short-lived. Human beings lived under completely different systems most of the times of history. So it is very short. Now, in addition, the system whereby the court has, I would say, almost supreme power is even shorter. That is, We have some elements of democracy in antiquity, in Athens and even in the Roman Republic. But there the court played absolutely no role in running the country. When Aristo considered these issues, he had an idea that the best system is democracy with aristocracy combined. That was his idea. It was understood in later days, that is, at the beginning of modern democracy, that is, with the American Revolution some 230, 40 years ago, that the combination would be the House of Legislative divided into two houses. One would be the aristocracy, like the English House of Lords, and England, by the way, was considered the best legal system at the time. The House of Lords and the House of Commons. Not the idea that the court would have some kind of supreme court power, but this was more or less an accident. It was not written in the Constitution, and there is an issue. Some people really thought that the power that the court had review power, and other people contested it, and so on. Now, in Europe, by the way, the power of the court is very, very recent. It is only, I mean, in Germany, it was during the Weimar Republic, but I understand only to moderate extent, and it began only after Second World War. So this experience is relatively small, and I will add that, by the way, that the American system of two houses, one the Senate and one the House of Commons, was based on this kind of Aristo idea. They considered the House of the Senate to be a kind of aristocracy, and therefore it's elected for 6 years and so on, and it's older people considered relatively to the House of Commons and so on. And the House of Commons would be the ordinary democracy. Eventually, it became completely different. Now, considering that we have relatively little experience or little historical experience, then one of the issues that actually you mentioned, Mr. Bushman, was that of what is the ambit of the court decisions. That is, we say political issues should not be decided by the court. That is, some political issues should be decided by the political process. That is, by Parliament and by compromising inside Parliament. And here I would mention that it is very important for for democracy that the people in the elected body will be able to negotiate with one another. If you find that the parties in Parliament are so hostile to one another that they can't really talk, then I think you already can identify a certain risk to democracy. Because one of the elements of democracy is moderation. That is of moderate people. If you get extreme people, and unfortunately, as I would say that in our parliament, we have groups of extreme people on both sides, this is actually, in a sense, risky for democracy. So, one question is, what kind of issues we want to decide, to be decided by the political system. And what we say, the idea was, it was already in Israel, but I think it is recognized all over that what we say, what political issues should be decided by the political bodies. But then we find that it is extremely difficult to define what is a political issue as distinguished from a pure legal issue that we want the court to decide. we have this decision, which I think was mentioned, of the Court of Human Rights in Europe, that environmental issues are legal issues. Apparently, this is a breakdown of all the distinctions between legal and political issues. And in fact, we did find it also in Israel. At the beginning, when the Supreme Court started, they said, well, certain issues are political issues. We are simply not dealing with them. Eventually now, when you look, you don't find any case saying this issue is a political issue and therefore we should not deal with it. Practically became the idea that every issue is a political issue, and the distinction between political and legal issues was completely broke down. In particular, this happened when you are, at least in my view, when they say that what is reasonable or unreasonable is a legal issue. And so the question is whether you want, for example, to impose a tax on certain activity that is detrimental to the environment. Is this reasonable? Is this unreasonable? In my view, it's a political issue. But if you frame it, but you can always frame it in a way that it is that it becomes a legal issue. So I think one thing is to try and find this kind of dividing line, that certain issues are really to be left over to Parliament. That I think is the first step. The other is the question, a certain question of balance. I assume that when people have to make decisions, whether it's in Parliament or in the court, they may make very good decisions. But they are also liable to make wrong decisions. And I think nobody is immune, not the courts and not the Parliament. The idea that the courts are always right, while Parliament is always wrong, I think it's not a very good approach. And therefore, one of the questions is, which is also new and very modern, is the whole idea of having a constitution. Now, what is a constitution? You want a framework. You want certain rules that are binding on the majority. The majority cannot act if there is a constitutional rule. Now the question is, how binding is the Constitution? Now, obviously you assume now that the majority is bound, but the court has a power to interpret the Constitution, and in fact, the court is not really bound by the Constitution if it is open to it to interpret the Constitution, and it can change always the interpretation. So so far as the court is concerned, the Constitution is much more flexible. The Constitution is inflexible for the political parties, but is very flexible for the court that can change its interpretation. If you look, for example, what happened in the United States by the Supreme Court, all of a sudden that you find, for example, that abortion is a constitutional issue and women have these kind of rights, the next day you find it's the very opposite. And the same happens with many others. I think the Constitution is not that binding upon the court. It is much more binding on the political parties. And then the question is how binding it should be, and that is whether you can. How difficult it is for the political party to change the Constitution. Obviously, it cannot be too easy. But the question is whether it should be too difficult. And this is one of the questions or problems that Europe is now facing with migration. The dealing with migration is subject to very strong restrictions, both by international agreement, like the agreement on the Covenant on the Human Rights, European human rights, and constitutional rights, and so on. So I think the constitution should not be too difficult for the political parties to change. There should be an ability. And also there should be an ability eventually to overcome judicial legislation. And here we come also to something that is very modern. The idea that courts protect human rights is not very new. It's certainly not in England. The idea was, first of all, it came in the Magna Carta, that is 13th century or so on, already, that the king cannot really judge his subjects. He is not free to impose the criminal law freely by his own hand. It didn't last very long. During the reign of Henry VIII, it completely broke down. But the idea was that you want an independent court, or what they said, judgment of their own peers, judgment by a jury, not judgment by the king or by the king court. But what happened in modern constitutional jurisdiction is that the courts actually legislate. I mean, the legislative function of the court is of huge importance. So both in Israel, in administrative law, much of administrative law is court law, is legislation by the court. And if this legislation is constitutional, it means that it's binding on Parliament, and Parliament cannot change it. I think the balance of power should be such that Parliament should be able to change it. Of course, not in ordinary majority, not in ordinary way, but if we assume that Parliament can make mistakes, but also the court can make mistakes, there should be a certain balance between these two powers to balance one another, also in a way that that there is a certain procedure that enables the court to amend the constitution. It shouldn't be too easy, but it shouldn't be impossible. Thank you. Thank you very much.
Thank you so much. I'm going to just abuse for a second my chairperson power just to tell you, since I'm also dealing with European Union law, it's often that Israel is compared with Poland and Hungary recently, and I just want you to know that the European Court of Justice, the one of the European Union, was thinking about how to deal with these questions of Hungary and Poland, especially that they are in the jurisdiction of, they are part of their sovereign powers, how they decide about election of judges and amending the constitution. And the court, which is a supranational court, it's a court outside Hungary and Poland, still decided that in the treaty establishing the European Union, there is a new provision, Article 2, which says these are the values on which the European Union is founded. You'll find the normal suspects, democracy, rule of law, and protection of fundamental rights, but also values that are not so common, like tolerance and solidarity and other values. At the same treaty, they write that the Union will respect the constitutional identity of the member states. And still, the court decided that the national constitutional identity cannot derogate from the values of Article 2 of the treaty. It's the same, it's Article 2 and Article 4.2 of the same document, the treaty, and still it elevated in a way the notion of the values of Article 2. Now they start, just to explain, they start again to fight what is the right meaning of the values of Article 2. The court doesn't shy away from defining what's the rule of law. I'm not sure how Danny Friedman will treat the rule of law, whether it's a legal question that we decide what is exactly the independence of the judiciary. The European Court of Justice is dealing with that. What's exactly democracy? How to balance between the two? So it might be that it might backlash against the European Court of Justice. We never know. And it's not that Poland and Hungary changed completely, as you all know. But it shows that maybe in the light of what Aaron Barak said, that courts should not shy away and still try to protect the values that they think about the rule of law. And I think in Israel, and maybe also in Germany, we still fight about what exactly are the scope of the fundamental rights in the Constitution, what's the powers. So just maybe a short question. We said here before that time is of essence, so constitutional courts should interfere, but they should be aware, or should be pay attention to the question of time. There was a debate in Germany, as you heard, whether they should say that the AfD cannot run. At the same time, it was said all the time, and even still today, that you cannot change the rules during the match. They are relatively weak, still relatively weak. They are not really neo-Nazis. So there is a long discussion whether it's legitimate even to change the rules. It might be too late, because it might be that in the next elections they will have at least third of the voices, and then they will be able to nominate judges to the Constitutional Court, and then might be a change. So what do you think? Are we still there that the courts can change, or we are beyond that already? Shortly, we don't have much time. So.
No, we had a prime minister called Sharon who had a very good trick. He would answer a reporter, this is not the right question, and answer what you want. So this is what I'm going to do now. You need to create some conflict. This is, I think, Aristotle, it was mentioned, he said there's no drama without a conflict, right? So I have to disagree or beg to differ from what Danny Friedman said about two things. Interpretation of the law. Should the court interpret, and this is how it legislates, right? When the American Constitution speaks of due process of law, 3 words. How many judgments we give? You need to interpret it. Without interpretation, it doesn't exist. So interpretation is necessary. You can't do without it. The other things I want to say is this. It's these two forces, the government or the majority, on one hand, and the court on the other hand, as Danny said, I agree, maybe right and wrong. We are not immune from making mistakes. There's a big difference between them. The government decides to act, war, peace, taxes. The court can stop or restrain it. They cannot act on their own. So I don't need to restrain the court. I need to restrain the government who has the force. Having been in government for many years, I know the power of government. Going all the way to corruption, God forbid, not in our country, but in other countries, okay? Going all the way to misuse of power. The court can make wrong or right decisions, but it's about stopping the power from being exerted. So you can't really equate them. It's two different things. Now, as you said, what is political and non-political? Unfortunately, if things are agreed, like racism is outside, then it's not a political issue, it's constitutional. When it becomes politics, racism, white supremacy, all sorts of things you heard, or Jewish supremacy, God forbid in our case now, is it political? I don't care. The word political doesn't mean a thing to me. Does it relate to basic human rights? It should be protected, even debated in politics. It should be decided by the court that this is against the basic rights that I as a person have. The political, non-political is not the right thing to me. I agree, it's not a black and white, clear definition. What one needs to do to allow the courts, in this imperfect world we live in, to restrain the force of the government that was elected by the majority, or else we end up with no democracy.
I would just add one point. I had an issue with the idea that the government acts and the court has only a power to stop it. That is, the court doesn't act, only the government acts. Now, first of all, the distinction between stopping and acting is very thin. For example, if the court decides that the government cannot take this and this measures against infiltrators, we decided not to do something. But the result of not doing may be the result of many more infiltrators coming into the country. It's not that things don't happen, but they do happen even if you decide something not to do. Secondly, the Israeli court often imposed duties on the government to act. Even there was a case of a building, first of all, of building defenses in the south, in the cities. They decide that you can't build, that you must protect the building, the public buildings against bombardment from the Gaza Strip. That the government must spend hundreds of millions on these kind of protections. That you have to build a synagogue in a certain place before you build another building. So it's not exactly fitting. And then when the when the human rights courts in Europe decided regarding the environment, that you must protect the environment, the people, against the dangers of the environment, obviously they order the governments to act in this way. They don't tell them not to act. They've got to be active to do something. So this distinction that was once, that came to explain at the time the rather limited power of the court is not more, isn't any more applicable, because what the court does is, in many cases, either it forces the government to act, or when it stops acting, it causes things to happen. That's all.
Thank you very much. Thank you very much for the whole panel. I did need to ask questions. I needed only to give them to be better. So we will continue onwards. Thank you so much.
Okay. We will now pause for the lighting of the Hanukkah candles in profound prayer to the return of the remaining Israeli hostage, Ran Gvili. We also pray for a speedy recovery for the wounded from the Sydney attack. I am honored to invite Member of Knesset Mansour Abbas, Chairman of the Ra'am Party, and Professor Yuli Tamir, former Minister of Education and President of Beth Berel College, for a dialogue revolving around Israel as a post-trauma nation.
מחכים להוראות. ערב טוב. אז ביקשו ממני להוביל את השיחה הזאת. וואי, זה מפחיד. כאילו לא יש פה, הוציאו לי פה שעון שמראה כל דקה שאנחנו צורכים. אז ביקשו ממני לפתוח את השיחה הזאת, ואני רוצה לפתוח בזה סיפור, ואז לשאול אותך, מנסור, איך אתה מתייחס לסוגיות אני התמודדתי איתם. אני מנהלת היום את מכללת בית ברל, מכללה שיש בה יהודים וערבים שחיים ביחד ועובדים ביחד ולומדים ביחד. זה לא אומר שאין מתחים, וזה לא אומר שהטראומות המשותפות לא צפות מדי יום ביומו. אז מעשה שהיה כך היה בשנה שעברה, ביום השואה, הגיעו אליי מספר סטודנטיות יהודיות מאוד נסערות, ואמרו לי שבצפירה של יום השואה הסטודנטים הערבים לא עמדו. משם זה התגלגל בכל מיני דרכים משונות, שכמובן עבר לערוץ 14 בתוך 3 דקות. 5 דקות אחרי זה כבר היה כתוב בערוץ 14 שהייתה מסיבה שהסטודנטים הערבים עשו, ו7 דקות אחר כך הייתה תמונה בערוץ 14 של מסיבה בכיכר אנטין, ולמעלה כתוב, זה הכיכר של אוניברסיטת תל אביב, כיכר אנטין. זה לא שכנע את ערוץ 14 שזה לא אצלנו, עובדות היו לא רלוונטיות. אבל אחרי ששכחה רגע הסערה התקשורתית, אז אני נכנסתי לכיתה ודיברתי עם הסטודנטים הערבים. אחת מהסיבות שהסטודנטיות היו מאוד נסערות זה שזה היה מיד אחרי חודש הרמדאן, ואנחנו ביקשנו מהסטודנטים לא לאכול ברמדאן בכיתות. והם אמרו, אנחנו התחשבנו בסטודנטים הערבים, והסטודנטים הערבים לא התחשבו בנו. ובשיחה עם הסטודנטים הערבים עלתה טענה שאני רוצה להעלות אותה כאן לשיחה בינינו. הם אמרו, תראי, יום השואה זה לא יום רגיל בשבילנו. אנחנו חושבים שהטראומה של השואה הולידה את הטראומה שלנו של הנכבה. ולכן קשה לנו מאוד להזדהות עם יום השואה. ואני רוצה להעלות את השאלה הזאת בפניך, ואיך אתה רואה את זה, ומה היית אתה עושה בסיטואציה הזאת?
המודעות של האזרחים הערבים בכלל לשואה היא דלה ביותר. אני למדתי 12 שנים בבית הספר. הנגיעה היחידה שהייתה לי עם השואה זה למדנו היסטוריה מודרנית ואז על מלחמת העולם השנייה. לכן אני לא רוצה לתת תירוץ לסטודנטים הערבים. זאת מציאות שלדעתי משרד החינוך כשל בה, וגם יש כישלון ברמת המנהיגות הערבית שלא ידעו לפתח את השיחה הנכונה, השיח הנכון מסביב לשואה, ולפרק את הקשר הזה בין השואה לבין הסכסוך, הנכבה 48 וכו'. כי כל האירוע הזה, לחבר בין האירועים ההיסטוריים, לדעתי זה לא נכון, וצריך לתת לשואה את מקומה ומעמדה גם בתודעה של האזרחים הערבים בכלל, בין בני אנוש. ההתמודדות הראשונה והעיקרית שלי עם השואה הייתה שנכנסתי לכנסת, ואז ביום השנה לשואה ולגבורה, יש לנו 2 ימים בכנסת. אחד, אפשר להגיד לו, היום הלאומי זה היום 28, וגם היום הבינלאומי. ואז אני בחרתי לשאת נאום ביום הלאומי, נקרא לו, לשואה ולגבורה, ולא רציתי שמישהו יכתוב לי את הנאום. הלכתי, למדתי, השקעתי, למדתי את השפה שדרכה מבטאים את הנושא של השואה, וגם שאלתי את עצמי, אני כמוסלמי וגם כערבי, אבל בעיקר בממד הערכי, מה היחס שלי כמוסלמי לשואה? וכמובן חיפשתי דברים בהקשר הזה, ומצאתי שהמופתי של בוסניה התייחס לנושא הזה בצורה מרשימה מאוד, והביע את העמדה הדתית המוסלמית לגבי השואה. אימצתי את זה, הזכרתי את זה בנאום, ונשאתי את הנאום הזה בכנסת. קיבלתי תגובות מאוסטרליה, מניו יורק, מצרפת, מכל מקום אחר בעולם, וכמובן בחברה הערבית. בהמשך הצעתי לשר החינוך, אמרתי לו, תראה, אני לא בגלל שזה נאום שלי, כאילו מצא חן בעיני רבים, לא בגלל שהנאום הזה הוא שלי, אבל אם התלמידים הערבים ילמדו על השואה מהנאום הזה שכתב אותו אחד, מנהיג ערבי, מוסלמי, דתי, ככה נצליח יותר לחבר את האזרחים הערביים, את התלמידים בבתי הספר לנושא של השואה. לצערי, הבקשה לא התקבלה, ולכן ההתמודדות של האזרחים הערבים עם השואה היא עדיין אינדיבידואלית. אין משהו סיסטמטי שאתה בא to educate, לחנך, להסביר, לפרק את המוקש הזה של מחברים בין השואה לבין הנכבה וכו'. ולכן יש מה לעשות בתחום הזה, ואני עדיין זוכר, אחרי שסיימתי את הנאום, זה היה מאוד מרגש, בא אליי חבר כנסת, שמע אותי בטלוויזיה מחוץ לעולם הכנסת, ועמד מולי ובוכה. ואז הבנתי שבאמת הצלחתי לגעת בנושא ולתת לשואה את המשמעות שלה, גם בהיבט האנושי וגם בהיבט הפוליטי והדתי וכו' וכו'. יש משפט שאני תמיד זוכר, לעולם זה לא יקרה, ונתתי לזה משמעות אוניברסלית וגם פרטיקולרית לעם היהודי מצד אחד, וברמה כללית בעולם כולו, אסור שאירוע כמו השואה יחזור על עצמו. ואז שבאנו לאירוע של 7 לאוקטובר, ויש אנשים שחיברו או הזכירו, התייחסו, אמרתי שלמעשה כל המנהיגים שעמדו על הדוכן הזה של הכנסת ודיברו לעולם זה לא יקרה, הם לא קיימו את ההבטחה שלהם וישנו והפקירו את חייהם של האזרחים. כמובן מי שעשה את הפשע הוא נושא באחריות, אבל יש אחריות גם על מי שלא הצליח למנוע את זה. זה גם אחד הדברים שלקחתי איתי בהמשך. נפגשתי עם רבים מהמנהיגים, אחרי שנכנסנו לקואליציה, הייתה לי הזדמנות לפגוש רבים מהמנהיגים שבאו לבקר מגרמניה, יושבת ראש הבונדסטאג, 2 מהסגניות שלה, השגריר כמה פעמים, הקודם והנוכחי, אני לא יודע אם הוא נמצא כאן, ובהתחלה יושבת ראש הבונדסטאג, ברברה באס, נראה לי, אני זוכר את השם שלה, באס, כן. והתחילה להסביר לי על מערכת היחסים בין גרמניה לישראל, אמרתי לה, אני מודע לזה, ואני מכיר את הייחודיות הזאת. ואנחנו רוצים לקחת את המערכת היחסים הזאת כמה צעדים קדימה, אבל אנחנו רוצים לראות את גרמניה גם עושה תפקיד מאוד חשוב באזור כולו, ומקדמת תהליך של פיוס ושלום בין שני העמים, העם היהודי, ישראלי, והעם הפלסטיני גם.
תגיד, איזה ציפייה או איזה תהליך אתה חושב החברה הישראלית צריכה לעבור כדי להיות מסוגלת להכיר גם בטראומה הפלסטינית?
תראי, כל אחד מתבצר בעמדות ומפחד להודות. לפחות ברמת הכאב, אני אומר, אנחנו לא צריכים לפחד. כי אנחנו יכולים לנהל מחלוקת מדינית, פוליטית, ואין ספק שהסכסוך הזה נמשך יותר מדי זמן ועקוב מדם, וכו'. אבל הציפייה הבסיסית שלי, מכל צד, גם הישראלי וגם הפלסטיני, לדעת להסתכל על כאבם של האחרים. לדעתי רק בשיטה הזאת אפשר לפרק את המוקשים ואת השיקולים הפוליטיים והמדיניים וההיסטוריים והאסטרטגיים וכל הדברים האלו. להסתכל על הכאב עצמו ולשאול את עצמך מה אתה יכול לעשות כדי להתמודד עם הכאב הזה. אני תמיד אמרתי, כמובן אנחנו בהקשר של מערכת היחסים בין גרמניה לישראל שהתפתחה בצורה מרשימה מאוד, למרות האירוע של השואה ומלחמת העולם השנייה וכו'. ואז אני שואל את עצמי, עברתי את זה גם בהקשר הכלל אירופאי. כאילו אם יבשת אירופה הצליחה להתגבר על היסטוריה של מלחמות, מלחמת העולם השנייה והראשונה ולפני זה מלחמת 30 הימים ו30 השנים ו100 שנים. אם אירופה הצליחה להתמודד עם ההיסטוריה הזאת והכאבים והמחלוקות ולבנות עתיד חדש לרמה שאנחנו מדברים על איחוד אירופי, אז האם אנחנו יכולים כאן להתגבר על הכאבים ועל המחלוקות ולבנות עתיד משותף? הפיוס בין מדינת ישראל, בין העם היהודי לעם הגרמני לגרמניה כמדינה, אין ספק שיש בו השראה.
אבל כמה אתה חושב זה נובע מכך שאירופה עברה תהליך של חילון והתרחקות מדת, ואנחנו שקועים עמוק בתוך תהליך של הקצנה דתית בשני הצדדים?
אני לא בטוח שהנושא קשור לדתיות. כי אירופה, לאורך החילוניות באירופה לא התחילה במלחמת העולם השנייה ולא הראשונה. וכל התהליך של הרנסנס וההגות החדשה, הפילוסופית והערכית וכו' וכו', התפתחה לאורך מאות שנים, וגם בצל ההתפתחות הזאת קרו דברים מאוד קשים. ולכן אני בא מגישה דתית מאוד. ובכל זאת אני רואה בדת מערכת של מוסר שגם יכולה לחבר בין האנשים. ולכן כמובן לדת יש כל מיני משמעויות אצל המון אנשים. אצלנו באסלאם יש כאלו שהם פציפיסטים ויש כאלו שהם ג'יהאדיסטים. זה מגוון רחב, וצריכים לשאול את השאלות, מה מביא את האנשים לגישה הזאת או האחרת וכו'. לכן אני לא מצמצם את הנושא, אם אנחנו עושים תהליך של חילון, אז אנחנו כן מצליחים. בעיקר הסכסוך הישראלי-פלסטיני הוא לאומי. ההגדרה הראשונית שלו, הסכסוך בין שתי תנועות לאומיות. אני זוכר למשל, שייח' עבדאללה נימר דרוויש, המייסד של התנועה האסלאמית בישראל, הוביל, אחרי שסיים את רשות, התפטר ב-98, ואז השקיע את כל המאמצים שלו לקדם תהליך ביחד עם רבנים של שלום דתי, קראו לזה, שלום דתי. ואני למשל, אני יכול להעיד על עצמי, הדתיות שלי היא שהביאה אותי להניח על השולחן את התהליך של שותפות אזרחית ערכית בתוך מדינת ישראל, ולקבל את האחר, ולהכיר בזכויותיו השונות, הלאומית והדתית והאנושית והכל, ולנסות לקדם תהליך של השתלבות. ואני לא רואה סתירה בין הדתיות שלי ובין התהליך הזה. זה
על כמה מחברי הכנסת היהודים בצד היותר דתי היית יכול להגיד משפט כזה?
תראי, אני רוצה להעיד למשל על הזרם הדתי-לאומי, ציונות דתית במובן של הזרם עצמו. אני מסתכל על המגזר הזה. אמנם אני רואה אנשים שנמצאים במפלגה של סמוטריץ' ובן גביר, אבל אני רואה אנשים ראויים ביותר בכחול לבן, חילי טרופר, גלעד קריב, שי פירון, ואני כל הזמן פוגש למשל פקידות בחירה במשרדי הממשלה שהם כיפות סרוגות. ואני חושב שיש אנשים נפלאים, ערכיים ביותר, כל הזמן רוצים לעזור, לפתור בעיות, שואלים אותי מה אנחנו יכולים לעזור. ולכן, לא, אני לא יכול לשפוט את כל הזרם, למשל הזרם הזה שנחשב לזרם ששילב דתיות ולאומיות. וזה מתכון מאוד מסוכן, גם אצלנו, אני תמיד אומר, דתיות אסלאמית, וגם עם הריח הזה של לאומיות, זה יוצר טירוף. אבל בכל זאת, כאשר אני מסתכל, לא, אני רואה אנשים, לדעתי, רוב המגזר הזה, הם נורמטיביים כמונו. ולכן, לא, אני לא חושב, יכול להיות בגלל שאני דתי, אני לא מסכים איתך בהקשר הזה. יש הבדל בין הדתיות של האנשים כדרך חיים, ובין, אוקיי, איזה מערכת שלטונית אנחנו רוצים לחיות בה. אני אישית בא ממפלגה שמרנית, אבל מאמין בשיטה הדמוקרטית ליברלית, וחושב שהיא מסגרת שיותר מתאימה לנהל מדינה שיש בה רבגוניות ויש לה זרמים שונים, ונותנת אפשרות, אחד כמוני, שבא במקור מתנועה אסלאמית, פלג דרומי, ומפלגה ערבית שמרנית וכו' וכו', להשתלב ולהתחבר לחלקים שונים בחברה וגם בפוליטיקה. למרות הקשיים.
א', אני מאוד מעריכה את העמדה שלך, ואני חושבת שאתה באמת יוצא דופן, וגם באמת בעניין הזה אתה דוגמה ומופת, ויש גם בין חברינו היהודים, מנית נדמה לי את רובם פה, אנשים שבאמת נושאים את הדגל של השילוב הדתי והליברלי, המתון והמקבל. אבל יש אנשים בימין שאומרים, זה נכון, אנשים כמו מנסור עבאס הם מתונים כל עוד הם מיעוט. כשהם יהיו רוב, זה לא יהיה ככה. מה אתה עונה להם?
כן, זאת, אפשר לחשוב על הגישה הזאת כגישה כזאת ביולוגית כאילו, שהאנשים האלו נולדו ככה והם יישארו ככה וה-DNA שלהם ככה. זה לא... תראי, אם מדברים על ההיבט למשל הדתי, האסלאם 2 מיליארד אנשים בעולם הזה, המוסלמים, ויש מגוון רחב של מוסלמים, יש מדינות היום שהתפתחו ויש שם מדינה דמוקרטית מתקדמת וכו' וכו', ויש כאלו שעדיין מדינות נכשלות. אנחנו באירוע של אוסטרליה לפני יומיים, שכאב לכולנו. איך אפשר לקבל אירוע ופיגוע מחריד כזה אנטישמי ואנטי אנושי ואנטי הכל? ופתאום אנחנו מגלים, האיש המדהים הזה שקוראים לו אחמד אל-אחמד, כאילו אחמד כפו בריבוע, מוסלמי, אוסטרלי, סורי במקור. איך הוא מתנפל על המחבל הזה, הפושע, ומסכן את עצמו, ולא חושב על משפחתו וילדיו, ולוקח את הנשק, ומציל אנשים. מישהו יבוא ויגיד, זה אירוע יחיד? לא, זה לא אירוע יחיד. אנשים חיים זה בתוך זה. היהודים והמוסלמים, והנוצרים כמובן, אצלנו במזרח, לאורך מאות שנים, חיו ביחד. אני לא מנסה לתאר תמונה שהיא אידיאלית. תמיד יש קשיים ובעיות וכו'. אבל בסך הכל, היסטוריה של יותר מ1,000 שנים, 1,200-300 שנים, מוסלמים, נוצרים ויהודים במזרח הזה, היו להם חיים סבירים ביחד. זה לא, סליחה, אין אירוע כזה של השואה שהתחולל באירופה וכו'. מה שאני מנסה שוב להגיד, חשוב גם שנבנה את האתוס הנכון, שגם מתכתב על במרכאות האמת ההיסטורית, אבל בוא נסתכל לעתיד, בוא נבנה את האתוס הנכון שישרת אותנו לעתיד. עכשיו, אם את באה ואומרת, מנסור, ברגע שהוא, מתחזק, משתלם, לאן אני יכול להגיע? שר, בסדר, מה אני יכול לעשות? כאילו, מה הסכנות שאני יכול לגלם בתהליך הזה? ורוצה לקעקע את היסודות של מדינת ישראל. דווקא אני מחזק את מדינת ישראל. דווקא הממשלה שפגעה בביטחון של מדינת ישראל ואזרחיה, זו ממשלת ימין על מלא. לא שהם מתכוונים לעשות את זה חס וחלילה, לא. אבל התחושה הזאת, הדורסנות, היהירות, ההתעסקות עם אג'נדה שהיא לא האג'נדה העיקרית של כל ממשלה. ולכן אמרתי, כל ממשלה שתכיל בתוכה שר ערבי, או כל קואליציה שתהיה בה מפלגה ערבית, לדעתי, היא תהיה ממשלה עירנית. למה עירנית? כי אף ראש ממשלה ולא שר ביטחון ולא רוצה שיגידו בגלל שהשותפים שלו ערבים ובגלל שהקואליציה שלו תלויה בערבים הוא יפקיר את ביטחונם של אזרחי מדינת ישראל. זה מצד אחד. מצד שני, אני לא חושב שהאינטרס שלי ושל האזרחים הערבים ולבוא ולפגוע בביטחונה של מדינת ישראל בדרך אפילו עקיפה. הרי אנחנו בסופו של דבר את הגדרתנו העצמית עשינו אותה. אנחנו רוצים שהפלסטינים יעשו את ההגדרה העצמית שלהם כמדינה פלסטין בגדה או ברצועה ליד מדינת ישראל. אבל אנחנו, האזרחים הערבים, עשינו את ההגדרה העצמית שלנו, אזרחי מדינת ישראל. ואומנם שהוויכוח כאן על זכויות, על מעמד, על השפעה, על פתרון של הבעיות, זה קיים, אבל זה בכל מדינה קיים. אבל אין לי הגדרה עצמית עכשיו אחרת שאני רוצה לממש. יש לי את האזרחות.
אני חושבת שזה באמת דברים נורא חשובים. לצערי, אני ממש מגיעה לחלקות הבאים. לצערי, נדמה לי שגם אנחנו, ונדמה לי שבמידה לא מעטה גם גרמניה, נשלטת על ידי פחד שהוא לא ממש רציונלי, מפני מה יקרה כשהאסלאם יתחזק, כשהדתיות תתחזק וכו'. אותי זה תמיד מרתק להאזין לך, וגם תמיד מרתק אותי לשמוע אנשים שמקשיבים לך, וזה לא נקלט אצלהם. שאומרים, איך זה יכול להיות שהקימו ממשלה עם מנסור עבאס? הוא קיצוני, ואני אומרת, אתם לא מקשיבים, ואני יודעת שהם לא מסוגלים להקשיב, אז אני חושבת שחלק מהדיון פה הוא דיון על איך מפתחים הקשבה. אמרת קודם חינוך. איך מפתחים הקשבה? שאנשים יקשיבו, מה שאמרת עכשיו על זה, אנחנו כבר מיצינו את ההגדרה העצמית שלנו, זה אולי המשפט הכי חשוב ששמעתי כבר הרבה זמן, ואני חושבת שהתפקיד של כולנו בפורום הזה, כי אנחנו מאוחדים במטרה שלנו, זה לגרום לזה להדהד ולגרום לאנשים להבין שזה תהליך שעובד גם לטובתם. קצת להסיר את הפחד ולהכניס קצת תקווה, אז תודה רבה ותמיד תענוג לדבר.
Thank you very much. We now move to the final panel, A Friendship Forged in Memory, marking 60 years of diplomatic relations between Germany and Israel. I am honored to invite Mr. Stefan Schabert, Ambassador of Germany to Israel, and Professor Fania Oz-Salzberger, Faculty of Law, University of Haifa. The panel will be moderated by Professor Gisela Dachs, journalist and professor at the Hebrew University of Jerusalem.
Well, for the last panel here, I just remind everyone that the title was of this wonderful conference, Never Again, A Friendship Forged in Memory. And it was supposed also to be a space of reflection of gaps in this relationship, of different meanings about this wording, and to reflect on a close relationship that did not emerge naturally. It really developed rather to speak against all odds. Just as a small reminder that Israeli passports until 1956 were marked valid for all countries except Germany. So to think that we have come a long way to today's close partnership where there's cooperation on almost every level between the two countries. So probably no one would have believed that after the foundation of the State of Israel in 1948, when also all Germans were banned from entering Israel. So it was national Israeli interests, German realpolitik, sometimes not always a wish for atonement, was part of it against the backdrop of also global political developments and a whole series of bilateral treaties, starting with the reparation agreement concluded in Luxembourg in 1952. So 8 decades after the Holocaust, the relations are really considered strong and stable. Berlin regards Jerusalem, or the other way around, Jerusalem regards Berlin as its second most important ally after Washington. And also Israel is the most important economic partner. Germany is the most important partner of Israel in the European Union. And as a symbol of trust, that was quite striking. At the 75th birthday, the State of Israel hosted the commander of the German Air Force, and there was a Luftwaffe Eurofighter flying in the airspace over Jerusalem and Tel Aviv, and the wings were painted in the flags of both countries. So 2 weeks ago, Germany has stationed its first operational Arrow 3 missile defense battery from Israel to counter long-range ballistic missile threats, particularly from Russia. So this is perhaps the most astonishing development in this special relationship. Israel is now arming and protecting Germany. But German-Israeli relations are sustained not only by treaties, but also by interpretation, by historians who complicate memory, by educators who transmit it, and by policymakers who act under its weight. So we have a close look at what is happening with Ambassador Stefan Seibert, and I just want to mention briefly, for those who don't know yet, I know he's very popular and well known in Israel, but he has served as the head of the German federal government press and information office, and as the German government spokesman from 2010 to 21 under Chancellor Merkel, and is ambassador in Israel since 22 in really troubling and difficult and hard times here. And we have Professor Fania Salzberger, who is an historian and writer, and mainly she has booked early on, has written a book in 2001, which was called Israelis in Berlin. And that was one of the very first books about the topic that intrigued her, seeing that Israelis were moving to Berlin, being fascinated by this global city which is not hiding its past. So really this book became a prism also of the Israeli-German dialogue, and it was quite visionary. And this was really before the wave of Israelis moving to Berlin started. So I want to ask both of you, how do we stand today? Who wants to start?
What an easy question to start with. First of all, I would start with a contradiction. I would say that, yes, you can build a relationship, a friendship, on remembering the past, but that is never enough. A friendship must have much more than a joint memory of the past. It must have a present, and it must have an idea of the future. And that's where things sometimes get complicated. But it is true that between Israel and Germany, to come to a joint assessment of the past, which for us Germans meant to look into the abyss that we had created, to look into the catastrophe of which we were the perpetrators, was absolutely necessary to even establish a relationship with the State of Israel. And for Israel, it was necessary to say, we will give these Germans a second chance, which miraculously Israel did. So that was important. But it is not the only thing about this friendship. There must be a common understanding of what a state should be like, a common understanding of values, and that goes into the present and the future.
Well, common understanding, shared values, where do the future generations stand on this?
Good evening. Thank you for the invitation. I will give a very brief historical perspective, not because I'm a historian, which I am, but because I'm already part of history myself. Over a quarter of a century, I've been taking part in so many celebrations and commemorations next to German partners, next to German ambassadors. To Israel, I celebrated the 40th year of anniversary of relationship, the 50th year. I sat with ambassadors Dressler and Kinderman and Michaelis and von Goetz and Vasum Reiner. Did I miss anybody? And now I'm very happy to meet. And each of these ambassadors, I'm sure President Company accepted, was a wonderful diplomat and human being and emissary of the Federal Republic of Germany. And yet, when I look at this perspective of my 25 years of German-Israeli dialogue or more, I can sum it for now with one very simple sentence. It was supposed to become easier. It was supposed to become easier, and for a while, we felt in some of the earlier anniversaries that we were going in a very good direction, both of remembering and encompassing and the memory, and of looking forward, and of a growing, dramatically growing space of German-Israeli relations. Which, if you look back at 60 years ago, that's a real historical perspective. I was a child. Dr. Rolf Pauls comes to Israel as the first ambassador of the Bundesrepublik, of the German Federal Republic, and he is himself a former Wehrmacht
The only one
soldier.
arm.
Only one arm, because there were different sensitivities then. Sometimes we are much more sensitive than people were in the 1960s. And there are demonstrations and very strong feelings about it, but Prime Minister Levi Eshkol and Chancellor Erhard have already signed the agreement, and the ambassadors are coming into their posts, and relationship is normalized and formalized. And Eshkol and Erhard are standing in the shadow in this story of these two great father figures, David Ben-Gurion and Konrad Adenauer, who are the architects of the renewal, the normalization of relations. Ben-Gurion and Adenauer, when they first meet in the Waldorf Astoria in New York in 1960, and then memorably Adenauer comes to visit New York, Ben-Gurion in Kibbutz Sde Boker in the late 1960s. It was all about leaders, statesmen, also women. Golda Meir was foreign minister, she was very deeply involved. But it was all among the leaderships then. By the 1980s, fast forward, it's beginning to be society to society, individuals to individuals. And civil society takes over, which is very much a shared value. And all the German political foundations are saying we are here to empower Israeli civil society. Some of them also Palestinian civil society. And to get it together in constant dialogue with German civil society. The reason why this anniversary is not like any previous anniversary, because of the situation that Israel has found itself in. For the first time, I think that the government of the Federal Republic of Germany is facing the issue that sometimes maybe one has to choose in its historical commitment to befriend and defend Israel between Israel, the government, and Israeli civil society. And that's a first. That has not happened before. But there is more than one Israel today, and more than one Israel that you have been sent to represent Germany in. And the big question, if I may pass it around, is how is the German government dealing with the current unprecedented strain on the very identity of Israel between government and a large part of civil society? I have my own opinion, of course, but I would be very happy to hear a difficult answer to a difficult question, I suppose.
Well, first of all, how you develop your democracy, which is what this is about, is this is up to the citizens of this country. So we will not interfere, but we take a very deep interest, and that brings me back to my first answer, because the Israel that we have this strong commitment to is not just any Israel, it is the Israel of the values of, say, the Declaration of Independence. It's a liberal democracy, and for decades we have told the world that we are so close to Israel because of our history and because it's the only democracy in the Middle East, which it is. If there were something to change, this would affect, of course, the nature of our relationship. That's why we take an interest, and we were fascinated, let's say in 23, in the early months of 23, to see hundreds of thousands of people every single Saturday, was it? Yeah. Demonstrate for their idea of what a liberal democracy should be like. But we will not interfere. We take an interest. We ask questions. I asked a lot of questions to members of the Israeli government, and they gave me their answers. Some of them thought that asking a question already was overstepping the boundaries of diplomacy, which I don't believe. But at the end of the day, it is this country and its people who has to decide where you want to go.
I mean, in a way, you have, remember, you were quite outspoken also in 22 when you arrived, and there were in Israel protests against the justice reform, and also during the...
I thought I was actually very reserved. No, I'm sorry, I can't, because people tell me, oh, you were so outspoken. We had questions. Mm-hmm. We had questions about checks and balances. We have an idea of what democracy is, and some of the suggestions or some of the parts of the minister's reform went into a completely different direction. So we had questions. And then the Minister of Justice told me, and others also, that this was an even better idea of democracy. No, I'm not laughing. I'm saying this is what they strongly believe in. Democracy as the rule of the majority. And after 4 years, the people can go to elections and say, did we like it or did we not? It is a very different idea of democracy. And so I wasn't outspoken, I had questions.
Yeah, I mean,
on behalf of my country.
I rather meant it in a way that you got involved in many things that people, by the way, were also appreciating. I mean, when it came to the hostages, you gave, in a very unbureaucratic way, citizenship, restored it to families from German origin very quickly, which was also an interesting sign of solidarity, of helping, of doing something. How did you go through these last 2 years since the 7th of October on a personal level?
I think if you live here, even if you're not Jewish, even if you're not an Israeli, even if your children are not in the IDF, if you really live here, you will have friends. You will have Jewish friends who cannot sleep at night because their children are in the IDF. I had a lot of contact with the hostage families because there were many German citizens among them. I also have Palestinian Israeli friends who lost 10 members of their family in Gaza. So you live here, you become part of the suffering that this means for the people of this region. And I never forget how it started. I absolutely know who is the culprit here and who started this war with the terrible atrocities on the 7th of October. And yet, the suffering encompasses both sides and made the last 2 years, let's say, a very intense experience. And at times, mentally, very difficult, even though I'm just a diplomat.
Were there moments where you were really thinking deeply how to explain or transmit to Berlin of what's happening here? Where you came to your limits of trying to bring this across?
Yes, what I tried to explain, the emotional part of living here is always difficult, of course, to convey to people who are 4 hours away and who read about this. I think there were parts of the tragedy that were never fully understood outside Israel in general. I think people never fully understood what it meant for the inhabitants of the villages and the kibbutzim along the northern border, for instance, which is completely undisputed Israeli territory, to be evacuated for 2 years and not to be able to live in Kiryat Shmona or in Chanita or whatever these places are called. This is so outrageous that a country would have to suffer that, even though, you know, the focus was completely on Otef Aza, but that also was a huge story of suffering. And people outside Israel had a hard time, you know. We tried to bring it home to people, but it wasn't completely understood at any moment, I think.
Did you go to Germany since the 7th of October?
Yes, I've been to Germany several times since the 7th of October. First, because I wrote another book that was published directly in German, called Germany and Israel after the 7th of October, in which, like every self-respecting Israeli, I told the German government what I think they should do. Now, of course, obviously, this is just a perspective or an opinion, but from the viewpoint of the liberal democratic part of Israeli society, also some social circles that were especially hit hard on the 7th of October, and unfortunately my circle was. The idea was to tell them as much as can be conveyed outside the borders of Israel, as the ambassador so well put it, about all the so-called sidelined agonies that people have barely recognized in the international community. So that was part of my task, but the other part was to point out to our German friends, and we have a lot of German friends, should I say still, I don't know, in the government, in the media, in the local echelons, in the Staaten, so many friends who were and are deeply confused, not just by the war in Gaza, also very much like by the war in Gaza, but also about the procedures, the processes going on within Israel, in Israel's public sphere, in Israel's civil society, in Israel's streets and squares. And on that, or the so-called constitutional coup d'etat, some friends in Germany told me, you should be quiet about that. We don't need it now. There is so much anti-Israeli sentiment going on. And this is, by the way, a very serious position. So much anti-Israelism that is tottering on the slippery slope of anti-Semitism, such as, in my view, the denial of the right of the state of Israel ever to have existed. On the wrong side of the slippery slope to anti-Semitism. Why should you now be coming with the domestic conflict or strife within Israeli society and politics? And I say because there is no such thing as domestic anymore in the world, and because our friends should know what is happening. Bottom line, if Germany is still committed to defend the state of Israel, as it has committed itself memorably in the past, by Willy Brandt, by Richard von Weizsäcker, by Angela Merkel, and so on. If Germany is really committed to defend the state of Israel, one crucial defense is about Israeli democracy. You have to defend Israeli democracy no less than the Israeli body politic, citizens, flesh and blood.
mean, that's a good question. How much should and can one do from the outside? You just said before, this is not a task to interfere. When does it become a universal question how to help a friend or how to push him or her?
Why are we even so interested? It's because you're Israel, and you also expect us to have a special relationship. I wholeheartedly think we have a special relationship which is not normal now and should never be. But that also brings with it an intense level of interest. We're much closer to you. You are much more important to us than some countries that are geographically closer to us. That's just the way it is. This is what we have together inherited from our history. And in that sense, we take a deep interest. But I can only repeat myself. We will not be able from the outside, and we're not trying from the outside, to steer you one way or the other. Nor should we, exactly. But to show where we stand, what our values are, what our idea of democracy is, this I think is part of a friendship. In a friendship, you're honest with each other. You listen to each other, but you also say, listen, this kind of confuses me. What do you mean by that? That's the kind of friendship we have with you, and that may make it sometimes a little cumbersome and make us a little annoying, but it's not meant to annoy. It's the depth of friendship that we have.
But here is where the interpretation of never again comes in. I mean, from Germany after 45, there were these two pillars in foreign policy saying human rights, international law, and standing with Israel. Things that have, in the last year, I mean, there was a weapon embargo for a while, which had been lifted again, that seemed to be in tension, which is a very German discussion, not one necessarily related to the relations with Israel. How did this come about, and where is this going?
The weapons embargo?
The relations, this tension, let's say, within German foreign policy.
This is something I think about a lot, because, and you touched upon it, we're seeing a widening gap, and it pains me to say that, between the democratic political circles in Germany and their position vis-à-vis Israel, and I'm very happy that they have that position, and growing parts of the public. Every poll taken over these past 12 months will tell you that there's growing and very strong criticism of Israel's conduct of the war. I'm not taking a position here, I'm just telling you that this is it. Where does that come from? It does not come from a majority of Germans being anti-Semitic. There are anti-Semites, horribly enough, and they show their vile ideology more openly than they used to. Bad, and we have to fight that. There are also people who come from an Islamist standpoint, and that is terrible, and we must absolutely be very clear about that and fight it. But when you have a poll that says that 65% of Germans think that the war has gone too far, then that's not 65% of Islamists or woke, crazy progressives at some university or anti-Semites. That is, very ordinary people who react to what they see on television. And by the way, of course, the way the war was covered was very, very different outside Israel than in Israel. So I think it's absolutely necessary to engage with these people. It's very necessary. I can only give advice here to my Israeli colleagues, and they're having a very difficult job right now to not dismiss this as, okay, it's all anti-Semites. They all swallow, Hamas propaganda. Some do, absolutely. But most of them, I think, are worried and critical, and that can be solved. There can be an engagement with these people, and there must be an engagement, because those are people who are really friends of Israel. But something disturbs them. Something has derailed this friendship, and we must get it back onto track.
I mean, this asymmetry in mutual perception is already existing since a while, that the irony is that Israelis are more open to Germany than the other way around. How do we get out of that? Will things calm down now that we are more or less after the war?
Well, first of all, we have to save Israel to some degree, maybe even from itself or part of it. We have to jumpstart Israeli democracy and also to come to a public reckoning with what happened on the 7th of October and its aftermath, the war in Gaza. We have a lot of work to do, and Mr. Seibert is absolutely right that we are not expecting, well, some of us are, any intervention from other sovereign countries in our own public decision-making and policy-making. So this is absolutely true. But there are two things we do need, and I think that you can reasonably supply from within your very acceptable and feasible limits that you have set out for us. One thing is that we need tough friendship, and real friendship has to be tough friendship. And for too many years I've been meeting friends of Israel and friends of the Jews in Germany, and some of them, not many, but some of them were carrying a bag of over-Philo-Semitism, which meant that they love the Jews and they love Israel, and Israel cannot go wrong. Israel can go wrong. And we don't need friends who are so philo-Semitic that they look at us with sparkling romantic eyes, because some of these people, by the way, could flip over to the other extreme very quickly. We need tough friends who are realistic about our weaknesses and about human weaknesses in general, and should tell tough things. I think in this context, in the current context, less to the Israeli nation than to the Israeli government. That is where tough friendship, I think, is needed and possible. Secondly, within Germany, as you mentioned correctly, and I've seen it outright, there is a growing anti-Israeli sentiment that is partially, perhaps the biggest building block, is totally legitimate critique of the way Israel conducted the war in Gaza, and the strong sense of empathy for the humanitarian disaster in Gaza. Same people are also very empathetic to the Israelis on the 7th of October. But then some of them make a quantum leap into denying Israel's right to exist, not only in history, but even today, and certainly calling upon Germany to withdraw the special relationship, to change its historical attitude to Israel, to drop the remembrance, the memory, the commitment, the shared moral values, and to treat Israel as it would any other country in the world. This is said by certain intellectuals in Germany, including, by the way, some Israelis who say the same. On this, I think we need a powerful signal from the German government that every legitimate critique of Israel is fine, because it is not so different from what we at home critique when we want to critique our government. But that the quantum leap from that into denial of Israel's right to exist is not fine. And that the special relationship changes over time, but should not be killed off unless Germany wants to lose part of its own soul.
So let me...
But I think you're getting that message from the German government, actually from every German government in recent history. You got exactly that message. We will always stand by this state. And when Chancellor Merz was here last week and he said in the press conference that we stand for Israel's right to exist as a state, Israel Hayom had an article the following day saying, why does he even say that? Why does he, it's paternalistic it's patronizing to repeat something that should go without saying.
It's because they don't know what's going on in Germany.
Okay, but actually, it did make me think.
So
Because yes, we should not even get into that debate. This state exists, it is internationally acknowledged, recognized, it has every, we don't have to go into that.
So let me ask you a very final question, because we're already out of time.
Yeah, I also have to run.
What would you tell the young generation in Germany in terms of what memory and never again means for them today when it comes to Israel?
First of all, and that's not rocket science, it still means and will always mean to know the facts. The facts must be taught in schools. We can only start anything from knowing the facts and from not giving in to all these people who try to dilute the facts and who try to give us alternative facts. There are no alternative facts. The facts are there, full stop. They need to be known by everyone to some extent. But that also is not enough. Unfortunately, this is an incredibly complex story. The conflict between Israel and the Palestinians is incredibly complex, and you cannot deal with it in a simplistic way. You have to learn to deal with complexity. And this is actually true for both sides. Also, many people who consider themselves to be extremely pro-Israeli spend very little time on thinking about the complexities on the Palestinian side. Complexity is the name of the game here, and we must try to educate, we must try to re-establish an atmosphere of conversation where we can deal with complexity, which right now, unfortunately, does not exist. This is one of the great victims of the war is a normal, proper atmosphere to talk about Israel and the Middle East. And we must regain that. Otherwise, I'm really worried.
Well, thank you very much.
To conclude today's conference, it is my honor to invite Professor Yaniv Roznai from the Rubinstein Center for Constitutional Challenges at Reichman University.
I know that everyone are tired and it's been a long day, so I'll do it hopefully very quick. Thank you very much, Ambassador. This has been, I think, quite a complex and touching day for many of us because we've discussed the Gaza war, anti-Semitism. For me personally, it has been quite moving. My own family was involved in the Bondi Beach incident and were there. So obviously this is quite astonishing. But I want to, in my really 2 minutes, just to try to link never again and trauma to constitutionalism. We know that constitutions are linked both to the past and to the future. They're always backward-looking, but also prospective-looking. Prospectively, it is this aspirational element of constitutions. It is where we as a polity are aiming to. This is why constitutional identity is different than national identity, because it points to a certain brighter future which we aspire to get to. Backward-looking constitutions often react to past events and to previous regimes' failures, atrocities, abuses, and injustices. They are an institutional negation of the past, what we call, in the Rubinstein Center, never again constitutionalism. In other words, constitutions often play this negative role as a lasting reminder of the recent past devastations, as an institutional attempt to transform and never return to past injustices. I think the best example comes from Germany. Article 79.3 of the German Basic Law, the Grundgesetz, was mentioned, according to which the basic values of the state as a constitutional democracy and human dignity can never be amended or touched. This is the so-called eternity clause, and it must be understood against the background of the Weimar Constitution, the Nazi rule, and the Holocaust. A similar statement, although Israeli style, has been recently expressed in the decision by the Israeli Supreme Court from January 1st, 2024, according to which the core values of the state as a Jewish and democratic cannot be denied, not even by the Knesset's constituent authority. In other words, when the Knesset enacts or amends basic laws. And this is a judicial attempt to protect the core values of the state against attacks. But courts or constitutions alone, as the German historical experience has taught us, cannot save democracy. Beyond any constitutional design, liberal democratic culture is important. And I want to quote from Tom Ginsburg and Aziz Hook's book, How to Save a Constitutional Democracy. And I quote, "In the end, constitutions cannot save democracy. Only small d Democrats can." In other words, we need people who understand the importance of democracy, who care about it, and who are willing to struggle for it. And here too we can learn from Germany. Article 20 of the Grundgesetz that was mentioned earlier refers to the right of resistance. According to this provision, all Germans shall have the right to resist any person seeking to abolish the constitutional order if no other remedy is available. And I think that this is what we have seen in Israel, again, without a formal explicit provision in 2023, with the massive public protest against the judicial overhaul. But the lesson here is that while institutions and mechanisms of checks and balances are important, the battle for democracy, as the title of this conference refers to, depends no less on education and on democratic literacy. And I hope that the relationship between Germany and Israel, as manifested by this conference, will allow us to better study how to maintain the core features of democracy while correcting its flaws, how to better educate our citizens, and how to make democracy a system that works for the people, but also by the people. Let me end with a round of thanks. Many people were involved in organizing this important event, and I wish to thank, first and foremost, Liav Orgad and Anne Cohen-Kohler for their leadership in organizing this event, Tal Schusinger-Beck, the engine behind everything that we do, Shir Tzfania and Riki Sprintzak for their assistance, and our students, Muhammad, Rani, Ili, Shiraz, Gal, and Afif, Tamar from the university's events department, and Shaked, Lital, and Inbar from the university's spokesman's office, and of course, to all our distinguished guests and participants, and you, our dear audience. I wish you all Chag Sameach, Happy Hanukkah, Merry Christmas, and long-standing friendship between Germany and Israel, and a future of liberal democracy to our children and grandchildren. Toda rabah.